Good morning, Commissioner.
Good. I think we're ready to begin. Morning, everyone. Could I just raise two short matters before we start the evidence? First, Ms. Peaty, we've had a request overnight. I think it came in just before 5 o'clock this morning for an extension of time in relation to 3 warning letters on the topic of belongership. Just to put this into context, the COI made a request for an affidavit and disclosure on the topic of belongership on the 29th of July. That request was made to the relevant minister, the Honourable Vincent Wheatley, and it requested that information by the 12th of August. In fact, an affidavit was provided by Mr. Smith, the Permanent Secretary, on the 26th of August. An unsworn draft had been provided a couple of days earlier. The same day, we wrote back to the IRU saying that the affidavit and disclosure were patently inadequate, and I directed a new affidavit to be prepared and lodged. That was lodged on the 10th of September. Warning letters went out on the subject on the basis of the analysis, such as we were able to do it in the short period of time. Letters were sent to the Premier, the Minister and the Cabinet on the 15th and 16th of September, asking for written responses by the 22nd and 23rd of September, respectively, with a date for oral evidence for the Minister of the 28th of September. Ms. Peaty, as you know, we received a letter at 5 o'clock this morning asking for a week's extension to that time. Now, the position, Ms. Peaty, as you know, with regard to the Premier, because the Premier won't be in the territory, and he kindly let us know that very quickly, we have rescheduled his appearances, including his appearance in relation to this topic, and they have been put off by a few days, and there will be no problem with his written responses coming in by the date you suggest, which is the 28th of September. However, as you know, the Minister is due to give evidence on the 28th of September, and it will be unhelpful if his written response, as you suggest, comes in after he's given his oral evidence. So I'm afraid, in respect of his request, we simply cannot give him until the 28th. His request, in fact, all of the requests in relation to this topic are very narrow, very short requests. He has one request in relation to one policy, and it's a matter which really should not take him, with the support of the IRU, very long to respond to. So, Ms. Peaty, I'm going to give him until 12 noon this Friday to put in his response. That will give me, and indeed counsel to the inquiry, very little time to prepare, but we will be prepared in time for the Minister to give his evidence on Tuesday. Is that all right?
Well, Commissioner, if I may, and you may have already considered this, having considered, including with legal counsel this morning, we wondered if the better course or the fairer course would be to deal with the Minister's hearing also around the same time as the Premier's hearing, so that we are able to produce a better response, which is more helpful to the COI, because we realise that you're working to very tight deadlines, but these events do go back some years, and the recollections of ministers and people involved have inevitably faded, and they need to look at the documents.
But in relation to this minister, the criticism goes to one policy. Some witnesses, I'm not sure whether this included the minister, it may not have done, this minister, but some ministers have already answered the point that's raised in the criticism in relation to a policy which on the face of it it's not consistent with the statute. That's the only point. It really is a very narrow point. And the problem with, as you say, putting this off so that the minister's evidence can be dealt with at the same time as the premier's evidence is lack of time. We have 2 days, which we've notified the premier about, to take his evidence, and we really want to make sure that we give the premier a proper length of time in which to give his evidence. I don't think it would be fair to him, and certainly not fair to us, to try and restrict that in some way by having the minister call on the same day. I see nothing unreasonable about asking the minister to respond to this point and give his evidence next Tuesday, Ms. Peaty.
I understand, Commissioner. And I'm grateful, Commissioner, also for the extension for the Premier's response. We will we will comply with the Friday deadline, and we'll do our best to put in the response that's going to be most helpful to the COI. Inevitably, with the ministers, all of them in House of Assembly and Cabinet today, it may be that they don't have quite the full and fair opportunity to respond as fully as they would like. So just to put that marker down.
I understand that both the House and the Cabinet are busy this week. I understand that, and you've set out the timetable. We know from ministers that they delegate these responses to their officials, and so I'm quite sure that the officials in relation to this have been busy working on the response to this request, as I know that they've been busy working on other things. As I say, it's a narrow point. Friday should give the minister adequate time to look at the response which is being prepared by, no doubt, by his officials, take any advice from you that he wishes to, and put in the response. It will be helpful if the response is as full as it can be, because the minister's giving evidence on Tuesday, and it will help us, and it will help him if the response is a full one. Good.
Yes, Commissioner. Just if I may, just a separate matter, and it may be that you were about to come on to this. We've had some emails with your team about whether you will require oral submissions on section 66 and 67 of the Constitution this afternoon. And I just wondered if there was any decision yet on whether those might be required, just for our own scheduling reasons here.
Thank you very much for speaking. A fair point. I mean, I'll ask Mr. Rowett to make any observations he wants to make. I would have thought we needed to hear the evidence first. The written submissions were very helpful, and I don't say that lightly, as it were. They were very helpful, and it's possible, Miss Peaty, that they will have covered everything that we will need to cover. But I just like, and I know it's not perfect, but I would like, subject to anything Mr. Rawat says, just to reserve the position until lunchtime, just to see how matters go. Mr. Rawat, do you want to add anything to that?
I'd agree with what you've just said, Commissioner. I think we do need to go through the Honourable Smith's evidence first, and then we can take a view.
Yes, thank you. Is that all right, Mr.
It's certainly all right, thank you. May I just suggest if we can have a little bit of notice, because I think it will be Sir Geoffrey who would be giving those oral submissions, and so we would need to request Mr. Chandler to provide a link or get him down to the centre or whatever. So no, you know, I hope that doesn't disrupt proceedings too much if we need a little bit of notice.
Request, Miss Peaty. We will do that. We'll make sure that you have enough notice, and it may well be that if as I say, it may be that we won't need any oral submissions, and if we do, it may be that we can make them very pointed, very focused. But thank you for raising that.
If I may, Mr. Commissioner, I would also probably have either some further submissions, or that I would like to make, either whether it's oral or written. It will be a matter for the Commission, but I would also like to make some further submissions with respect to your request that was for written submissions.
Mr. Figgleton-Davies, we've got your oral submissions.
Written.
Sorry, your written submissions. Is it what I was going to do is simply leave it until the end of the evidence and then see whether the written submissions that we've had leave any holes?
Well, there's some further parts that I would like to add to it. I've seen, I was away at the time that these submissions were made, and I have reviewed them, and I thought that perhaps it would be helpful for an additional point of view to be given to the Commission as to how certain things can be interpreted.
Okay. Well, what I'll do is let's hear the evidence and see where we are, Mr. Figgleton-Davies. But don't let me forget that, and we'll come back to it.
Great.
I'm sorry. The other thing I wanted to do is just to apologise to the witness for the delay this morning. I'm sorry. It was just something which cropped up. But thank you for being patient with us, and thank you for your time. Mr. Rawat.
Thank you, Commissioner. Our witness today is the Honourable Neville Smith. Honourable Smith, can I join in the Commissioner's apology for the delay that you've had to experience today, but also to thank you for returning to give further evidence to the Commission. I think you've given evidence once before, some time ago. On that occasion, you made an affirmation. You don't need to take an oath or an affirmation again. You're still bound by that previous affirmation. Could I ask you just to remember to keep your voice up and to speak slowly? The microphone that you see in front of you will not amplify. So if anything, I'd suggest that you pull it a little closer to you. The reason I make that request, of course, is because we have a remote stenographer. It's important that the evidence that you give today is accurately and clearly recorded. One thing that both you and I will have to try and avoid is speaking over each other. And if that happens, leave it to me and I'll stop and allow you to finish your answer.
No problem.
You will have on your left the hearing bundle, which has previously been sent to you. It's in two parts, and we'll go to those as we go through your evidence. You should also have on the desk with you some additional loose documents. Firstly, is a letter that was sent to you there, but then also, and I think you've bought your own, a copy of a response that you provided to the Commissioner.
Yes, I did.
What you'll see towards the far end, I think, are copies of two resolutions from 2019, which you'll be familiar with. They were not in the bundle, but we bought them. Well, it was something that we discussed on the last time that you came to give evidence, but in case it comes up again, they're there for you. Now, you'll remember that you gave evidence to the Commissioner on the 15th of June, earlier this year, and you were asked then questions about the various business interests that you had declared to the Registrar of Interests, and you had by that date completed and submitted 3 declarations of interest. That's right, isn't it?
Great.
And that was for the 3 years that you had been a member of the House of Assembly.
Yes, Commissioner.
Now, do you remember at that time that you described yourself as the Managing Director of Caribbean Security Limited?
Yes, Commissioner.
And you also explained, didn't you, that you were also the Managing Director of NS Cleaning and Imports?
Yes, Commissioner.
Now, I'm going to stop you there, Neville, Mr. Smith, because you do need to keep your voice up a little more.
Okay, no problem.
And you then confirmed that Frontline Sounds, or also I think sometimes described as Frontline Systems, is a DBA of which you are the sole owner.
Yes, Commissioner.
And you then explained during the course of your evidence on the 15th of June that you were the managing director of International Construction Limited, which was a partnership with Jerome Macmillan.
Yes, Commissioner.
You're a member also of a trade license company called NNL Charter.
Yes, Commissioner.
And you also had another DBA called NS Water Services, and also a mixed DBA as well. I've forgotten the name of the mixed DBA, but I'll remind myself of that in a moment. It's NS Water. Yes, NS Water Services is the mixed DBA. I understand.
Right.
Now, when you attended, you also, that was the day that you provided those two resolutions that I just drew your attention to, and they're number 8 of 2019 and number 9 of 2019, both of which were gazetted on the 12th of August, and they were, as you explained, in relation to 2 contracts that Frontline, but you explained that you had done this, and this was your word, you had done this because you wanted to be transparent.
Yes, Commissioner.
And your position on the 15th of June from the evidence you gave was that that wish to be transparent was going to be behind your decision that you would do it with every contract, even if it was just with the statutory board.
I would not say that, Commissioner. What I said is I brought it there then because I was trying to be transparent. But after being informed by members and by the former AG, the previous AG, that there's no need to do it, I decided I would not do it anymore.
Could we go to your evidence, please? If we go to 192, if you take the smaller bundle. It's page 191 in that bundle.
191?
Yes, please. If we, just to give you, this is part of the transcript of the 15th of June hearing, which is day 11 of the Commission's proceedings. And you were the second witness of that day. Your evidence begins actually in this bundle at page 132. But if you just turn briefly to page 189, please. You see, Honourable Smith, that we're at line 12. That's when we started, I started asking you questions about the 2 resolutions that you had brought that day to the Commission. And we went through them and you explained what they were for. And if we go to page 191, and we go to line 8, please, on page 191. What I then asked you was, so, but even though, because you're a director of the company that wants to contract with government, unless you want to vacate your seat, you have to get yourself exempted. Is that right? And your answer was correct. But can I also say that Festivals and Fairs is a statutory body, which I did not have to bring this to the House of Assembly, but I did it because I want to be transparent. I then asked you, now that's very helpful actually, because you say that it's a statutory body and therefore you didn't have to bring it to the House of Assembly. What was that based on? And your answer was, after speaking to the past AG, I was told that statutory bodies do not have to come to the House of Assembly to declare. I then said, I see, and you then said the exemption from the past AG. So I then asked, so if you could have, as director of Frontline Systems, entered into any number of contracts with any number of statutory bodies, and you wouldn't have had to seek exemptions from the need to vacate your seat? Is that what it comes down to? And your answer, Honourable Smith, was this: I still would have done it because I want to be transparent. Right. And then I confirmed that, whether it was your understanding that you weren't obliged to do it, and you said correct. And I then asked, so you could have a contract with any statutory body, you would not be obliged to disclose that to the House of Assembly. And you said correct. Now it would seem that even before you took the decision to take the 2 frontline contracts forward to a resolution, you were already aware from the previous AG that you didn't actually have to do it.
Correct.
But you made the decision to do it.
Correct.
Now, your answer, I still would have done it because I want to be transparent, which was in response to a question of, well, you could have as many contracts with as many statutory bodies as you like, and you wouldn't have to say a thing. Correct. You said I still would have done it. Now that suggests that your intent in June 2021 was that because it was important to be transparent, where you had a contract with a statutory body, you would seek a resolution. Has that changed?
I would say it changed in a way, Commissioner, because what I've learned after I brought that contract to the House of Assembly, the kind of backlash that I was given, knowing that it wasn't supposed to come. I think you'll see that a lot of times you'll hear people talking that they shouldn't get this, you get this by this way. So to me, to avoid that kind of backlash, I left it because it was not supposed to be the House.
I'm sorry, a backlash from whom?
From the public. Because what happened, you're being very judgmental. Once you see somebody get a contract, especially in that area, frontline, they were saying that I shouldn't have got a contract, I knew about a contract. So I avoided, the frontline I did it, but for others I avoided that because since it's not supposed to be there, why bring it?
But let me just get this clear. You disclosed 2 contracts with statutory bodies,
correct,
with statutory boards. Although you were then knew because you'd been advised that it wasn't necessary, you did it because you wanted to be transparent. You saw the advantages of openness and transparency of governance. As I understand it, because you were transparent, the members of the public were concerned about these contracts. That's what transparency is all about, transparency. And so you stopped being transparent.
Commissioner, it's not I stopped being transparent. What happened is that, you see, when it's the open season to talk, and when you go to the House of Assembly and you put this on the table and people do not know the full extent of what took place, there's a lot of talk. There's a bidding process in place. You go through the same process, you bid, and if you win the bid, but still people will talk and say, well, he knew about this, he got it this way, he got it that way. So it becomes frustrating as a business person to hear your name being pulled in the mud when you know you do the right thing. The documents are there to be seen that it was transparent. I took our steps that it was transparent. So when I hear other members saying, why should it come to the House? When I hear other members arguing, why bring this to the House and it's not supposed to be the House? You're wasting the House time.
I understand that.
That was what I was being told, because it's not supposed to come to the House because it's not a statutory body, do not bring things to the House.
I mean, that's a different point.
So that's why I decided at this time not to bring them to the House anymore.
Okay, I understand that. Thank you.
Just to clarify there, Honourable Smith, you said that your backlash had, or the backlash had 2 aspects.
Right.
Firstly, a backlash from the public, as in, how did he get that contract? Is that right?
Correct.
And then a backlash from other members of the House of Assembly for wasting House of Assembly time for bringing something forward.
That's not supposed to come to the House.
If you turn to 194, please, in the bundle. Now, if you look at the top and the answer you gave there at 1, and I can take you back if you need it, Honourable Smith, but what you explained was that Frontline Systems had been bidding for festival contracts, if I can say that, for 20 years.
Correct.
And in fact, it's right at the top there. And you say that sometimes you win the bid, sometimes you lose the bid. And that you had been doing that before you had political aspirations. And then I asked you this. I said, that's again an important point, because what you chose to do was in relation to one specific contract to seek an exemption from the House of Assembly. And what your advice was that you wouldn't actually need to do that. And you said this: Yes, but I did, because of the atmosphere in the BVI. Once you're a political member, everybody looks at you as corrupt somewhat. So I decided to avoid any sort of confusion, any talk. Let me just be transparent with it and get it out. And that's why I did it. Now, you took that step, you said then, to avoid confusion and talk. But by now deciding that in future you will not seek exemption on statutory board contracts, are you not feeding the confusion and feeding the talk?
Commissioner, I'll say no in a way. Maybe I'll have to find another way of getting it out there, but not bring it to the House. So if you mean I have to find, I'm always open for suggestions, but by me bringing something to the House that does not need to be to the House, I don't want to do that anymore. But if you mean find other means and ways of getting out there so that the people could see that it's transparent, I have no problem with that. So I'm always open for suggestions.
Well, if we,
I'm sorry to interrupt, Mr. Howard. I understand that answer completely. Just to go back half a step, you had advice from the attorney that it was not necessary to disclose, to get exemptions from the House of Assembly in relation to contracts between you or associated companies and entities on the one hand, and statutory boards.
Can you please repeat that?
So you had advice from the Attorney General that you don't have to disclose, you don't have to get exemptions from the House in respect of contracts between you and various entities in which you're involved on the one hand, and statutory boards as opposed to the government. And
statutory boards.
Yes, yes.
And statutory boards.
That's, sorry, this isn't really a question, it's just an observation, but that is fine in a sense if and the attorney's written submissions on this make this very clear, the government on the one hand, of which the House is involved, and the statutory boards with which you're contracting are distinct and separate, and the statutory boards are independent and autonomous.
Correct.
I mean, because that position is really only justifiable, probably, on the basis that the statutory boards don't form part of the government. They are independent and autonomous.
Correct.
That seems to me to be right.
Correct, Commissioner. Yeah. And if I may add, I mean, if this was to be clearly put, maybe what should happen, it should be written that statutory boards shouldn't bring things to the House if that's the case. If there's a contract within anyone, maybe that need to be put into place to be clear.
I understand that. Okay. But if the statutory boards are truly independent and autonomous and operating outside the government and without government, I was going to say interference, without the government playing a part in the boards, an operational part in the boards, that's fine, isn't it? Because the boards make their own decisions, independent of government. If they contract with somebody in the House, well, there you are. They're just an independent legal person contracting with a member of the House. I'm just trying to see the logic behind the Attorney General's advice, and it seems to me that there is a logic if the statutory boards are truly autonomous and independent.
Thank you, Commissioner.
Yes, thank you.
If we turn to the two resolutions of 2019, please, Honourable Smith, and those are the two sheets that we've got that are loose linked. So we went through those on the last occasion, but they are both resolutions. They're resolutions number 8 and number 9 of 2019, as I've said, gazetted on the 12th of August 2019. But they came and were passed by the House of Assembly, as we see at the bottom of each page, on the 25th of July 2019. Can you remember, when did you first seek those resolutions?
Commissioner, I'm not too sure when. It's a long time, and I know I brought it to the attention of the speaker, but I'm not too sure when exactly I brought him. Because once again, I was in between two minds. I was told it do not have to come to the house, but I insisted I wanted to bring them to the house. But I'm not too sure the day that I brought him.
If we look at the resolution number 8 concerns a contract that Frontline Systems had with the Virgin Islands Festivals and Fairs Committee for 2 periods, 25th of July to 5th of August 2019, and 6th of August to 7th of August, respectively. And then the second resolution, number 9, concerned a separate contract for the period 9th to 10th of August. Now, taking the earliest date of those, the 25th of July, that's when the contract was due to start. Do you remember seeking the resolution after the contract had been accepted, immediately after it was accepted, or?
It was accepted after. The contract was signed before.
Yes.
Yes.
But you've got basically between March 2019, when you come into the House of Assembly, and 25th of July. Can you remember how long it took as a process from you making your decision to speak to the speaker and take this forward to it coming before the House?
I'm not too sure when, but like I said to him, the fact that it was not supposed to come to the House, I was instructed. I mean, what happened with that is that it's like, it was no rush at this time because I knew it was not supposed to come to the House. But because, like I said, the atmosphere in the House, I decided to bring it. And I know I brought it sometime after. I don't know whether it's a month, but I brought it after the contract was signed, yes.
I think the speaker in the evidence that you've put in from the speaker says that it was several times, but starting in January.
No, you're talking about
that's for
the different.
I'm sorry.
Right.
No,
I might be able to.
Good.
No, you're right. That's the later
help with it though, because if you take the larger leverage file, please, Honourable Smith.
So we finish with this.
For the time being, but turn up page 1111.
Page 11.
We're looking at we were looking at a resolution made by the House in July 2019. You've now got a.
Excuse me, I never got it wrong. Is this one you mean?
Yes, this one, but 1111.
111?
No, 1111.
Sorry.
What we've got is a document that you've disclosed to the Commissioner, and it is a Frontline Systems contract agreement, which is it's recorded as between the Road Town Festival Committee and Frontline Systems, but it's for the period July 25th to August 5th. Which seems to cover one of the periods that was in that resolution. And it's the cost is $268,000. Now, would that do you think be the contract that relates to one of the resolutions that you brought to the House?
Yes, Commissioner, that is the one for Road Town.
Right. And I think this was a point you made on the last occasion, but given the price of it, would that have been something that would have gone out to tender?
It would have.
And what we can see is that the date of it, written in the American style, is the 24th of June.
Yes, Commissioner.
So at some point between the we can at least narrow the window down. So at some point between the 24th of June and the 25th of July was when you made the decision to take the matter before the House of Assembly to seek an exemption.
Yes, Commissioner.
Before we leave Frontline Systems, if you turn up 1100 to 1100. This is a second contract agreement, but it's in relation to what's called the Carrot Bay Festival Committee. It's not signed or dated. The full fee that's proposed is $58,000. But it gives us the dates that your Frontline Systems was going to be engaged as between the 9th to the 10th of August. So look, if you look at resolution number 9, that speaks of hiring out equipment to the Virgin Islands Festival Fairs Committee for the period 9th to the 10th of August. Is that the contract that relates to that resolution?
Yes, Commissioner.
Now, if I think we can probably keep that bundle open in front of you for the time being, please, Honourable Smith. But if I just give some background to how we've reached today. During your evidence on the last occasion, you agreed to provide details of the frontline contracts to the Commissioner. And following the hearing on the COI, the Commission on the same day wrote asking for further details in relation to all stages of the process of getting a contract, whether that contract was between you or a company or business that you were engaged in, but with the government of the Virgin Islands, and together with copies of any documentation. You subsequently provided that documentation through your legal representatives on the 20th of July 2021. And on the 27th of July, the Commissioner asked you to provide an affidavit concerning various contracts that you had with the government of the Virgin Islands. And that affidavit we can find in this smaller bundle at page 57. That's the first page, Honourable Smith, but if you turn to the next page, can you confirm that that affidavit carries your name and signature?
Yes, Commissioner.
Now, attached to it, and we'll come back to them in due course, but are two resolutions. Resolution number 10 of 2021 and resolution number 11 of 2021, both gazetted on the 12th of August 2021, both passed by the House on the 29th of July 2021. That's right, isn't it?
Yes, Commissioner.
And they both concern contracts that you, through companies with which you're involved, entered into with the government of the Virgin Islands.
Yes, Commissioner.
Now, Honourable Smith, on the 6th of September, the Commission sent you what it describes as a warning letter, which I think in the past has been known as a salmon letter. Warning letters is a term that's used in inquiries, but its purpose is to give the recipient notice of potential criticisms that arise from the evidence that an inquiry has gathered. What I should stress, as I have done to others, is that such a letter and the criticisms in it are not and should not be taken as either the provisional or concluded view of the Commission. But in turn, you provided a written response to, together with some additional documents, and I can see that you've brought a copy with you. Now, you provided that on the 13th of September, and the Commission asked you on the same day to provide a version signed with a statement of truth. Was there any reason you didn't want to sign the written response?
Sorry, Commissioner, maybe I missed that because I have not seen that. Because what was given to me, I make sure I signed and I did. So if there's something that was left off, I apologize for that, but I have not seen that.
Could I just break that down a little, please, Honourable
Sure.
Smith? If you just look at your written response,
Right.
copy that the Commission has is 10 pages.
One of my pitch,
Well,
the one I sent to you is document.
yes, I mean, I'm looking at the version, the
Right.
copy that you sent us.
Right.
The page 10 doesn't have a signature on it.
Well, I apologize for that. I didn't know how to put a signature on that. So I do apologize for that.
Were you made aware of the Commissioner's protocol on the provision of written evidence, which asks for written evidence to be signed?
Like I said, Commissioner, I think maybe I missed that. I mean, I tried my best to do everything else. I had no one to help me do this. I did it on my own. I really to how I understood it. If I missed off that, not signing it, I apologize for that.
No criticisms intended. I'm just trying to clarify what happened, because the email of the 13th of September, which asked for a signed version, was copied to your legal representatives. Did your legal representatives not draw it to your attention?
No, Commissioner.
Did you, in fact, I mean, are you happy to provide a signed version in due course?
Which is that means this document I have signed?
Yes.
I have no problem with that.
And can I, can I ask you, for the purpose of the transcript, to confirm that you are content for that written response that we've received to form part of the evidence before the Commission?
From me, the one that I would, correct, I do.
I think you've explained that you drafted this yourself.
Correct.
Could you just clarify one point for us, please? If you go to page 3 of it. You see the paragraphs number 2 and number 3 in the document. The paragraph number 2 begins, "We note," right, and paragraph number 3 begins, "We further note." Mm-hmm. And that's when you, as you go through your response, Honourable Smith, you deal with each potential criticism in order. But that phrase or term, "we note" and "we further note" appears. And I suppose the question is why did you decide to use the royal "we"?
Just a figure of speech, as from being working in a legal firm for a few times, I get that saying "we" instead of I say "we." That's it.
All right. Thank you. Okay. Well, what I'd like to do now, Honourable Smith, is just take you through the criticisms. Now, the letter that we have sent to you, the warning letter, is a confidential document. It has not been published by the Commission, and it remains confidential. But the approach that I have adopted with other witnesses is to summarize the criticism and then to go through the written response with them. Your written response forms part of the evidence. You've accepted that, so I don't need to read it all out. But what I'll do is I'll ask you additional questions, but also summarize your response, if I may.
Good.
Now, if we turn to the warning letter to the back, to the appendix, please. There's a copy that's in. Oh, thank you. What it sets out are section 67. If you go to the appendix at the end, it sets out, first of all, section 66 and 67 of the Constitution, because and that is, if I make clear, the reason we've asked you to return, and that's to ask you further questions about how those provisions relate to you, and essentially how you go about complying with the requirements on you when seeking election to declare contracts with government, and once elected, when placed in a position where you may have to seek exemption from the requirement to vacate your seat. So it sets that out. But if you turn through the document, please, Honourable Smith, to the, I think, page which begins by way of resolution number 10 of 2021. If you have that.
Yes.
So what that refers to, and it's the resolution that's appended to the affidavit that you provided, but by way of resolution number 10 of 2021, passed by the House of Assembly on 29th of July, Honourable Neville Smith was exempted from vacating his seat as an elected member of the House of Assembly under section 67 of the Constitution on a motion moved by the Honourable Andrew Foy, Premier and Minister of Finance. This was stated to be in respect of his directorship of Caribbean Security Limited, following the government of the Virgin Islands through the Ministry of Finance entering into a contract with Caribbean Security Limited on the 8th of April 2021. And that contract, if I summarise, was essentially to provide what we could call security systems in the Department of Information Technology, Telephone Services Management, Inland Revenue and Treasury Departments, and for additional installation, including building wildfire systems at relocation offices located at various points. And the total contract price was $72,917.56. So that was the first resolution, Honourable Smith.
Correct.
There was a second resolution, which was resolution number 11 of 2021, again passed by the House of Assembly on the same day, again exempting you from vacating your seat as an elected member, again moved by the Honourable Premier and Minister of Finance. But this was in respect of a different contract that Caribbean Security Limited had with the government of the British Virgin Islands.
Correct.
And that was a contract which was entered into on the 26th of November 2020, and to provide services for the installation of ICT equipment for the Royal Virgin Islands Police Force at various locations. And that was for a total contract price of $99,285. What is the warning letter then says is that the Honourable Neville Smith obtained the section 67 exemptions on the 29th of July, despite the contracts being entered into on the 29th of November 2021 and the 8th of April 2021. On the available evidence, it appears that the Honourable Smith failed to obtain an exemption under section 67 of the Constitution from vacating his seat as an elected member of the House of Assembly prior to becoming a party to such contracts, or if applicable, as soon as practicable after becoming otherwise interested in such contracts. Honourable Neville Smith acted contrary to and/or was in breach of section 67 of the Constitution. I'm going to pause there, Honourable Smith. If we just remind ourselves of that part of section 67 of the Constitution, you will find it in the smaller bundle at page 35. 36. Section 67(3), or Section 67 deals with, amongst other things, the circumstances in which a member of the House of Assembly has to vacate his or her seat. And Section 67(3) at E gives one of those circumstances if he or she becomes a party to any contract with the government of the Virgin Islands for or on account of the public service, or if any firm in which he or she is a partner or any company of which he or she is a director or manager becomes a party to any such contract, or if he or she becomes a partner in a firm or a director or manager of a company which is a party to any such contract. Now, there is a caveat to that, which we find at 7, subsection 7, which says that if in the circumstances it appears just to the House of Assembly to do so, the House may exempt any elected member from vacating his or her seat under subsection 3E, if such a member, before becoming a party to such contract as there described, or before or as soon as practicable after becoming otherwise interested in such contract, open brackets, whether as a partner in a firm or director or manager of a company, close brackets, discloses to the House the nature of such contract and his or her interest or the interest of any such firm or company in it. So as we've seen and as you've done, Honourable Smith, if you become involved in a contract, you have to go to the House to get a resolution exempting you from vacating your seat. And as you've explained to the Commissioner, if it's a statutory board, your understanding is you don't have to do that.
Correct.
If we look at the two contracts involved with this criticism, which were the subject of the resolution.
I'm sorry, Ms. Rowett. Just while we're on section 67, and this this may be a matter for legal submission, so I don't want you to give any legal submissions, but the structure of this seems fairly clear. Firstly, that under 67(3), an elected member of the House shall also vacate his seat, so that's mandatory in the circumstances set out in subsection 3, including leaving out the irrelevant words, if any company of which he is a director becomes a party to a contract with the government.
Correct.
And then there's an exemption because the House of Assembly can exempt any elected member from vacating his or her seat under 3E, which we've just looked at, if such member, before becoming a party to such contract as they're described, or before or as soon as practicable after becoming otherwise interested in such contract, discloses to the House the nature of such contract. Just pausing there. So that's a condition. What the member has to do, if he doesn't do it before the contract signed, is as soon as practicable, disclose to the House the contract, and then the contract, and then the House then is able to exempt it. That's the structure as I see it.
Correct, Commissioner, but may I add something to that? If you say at a reasonable time meaning if I know when it is as well, Commissioner, because
I'm sorry,
in this condition.
But in respect of where? In respect of 3E or in respect of 7?
7, once you bring it to a reasonable time.
And where do you see that?
The same as practicable time. Reasonable is the same. I assume reasonable time is the same as that.
Well, hold on.
Practical time.
That is a legal submission, which I'll hear from Mr. Davis on. There is in law possibly a difference between a reasonable time and as soon as practicable. As soon as practicable normally means as soon as possible.
Commissioner, and may I said, and as soon as I know. Commissioner, can I say, with regards to Frontline and Caribbean Security, it's two different entities in terms of one, I'm a solo ownership in Frontline. I know the day-to-day stuff. I used to know the day-to-day stuff at Frontline, which I don't know now, but then I was in control of Frontline. In terms of Caribbean Security, we have a business partner who does the day-to-day running of Caribbean Security. I am not privy to most of whatever has been done with contracts. I submitted that as evidence to you all as well, because that is something that's very serious, whereas I myself have pulled myself away from those entities since being elected. The most I'm involved with the companies is, whereas because I'm a signatory with checks, I may sign the checks and have my wife deal with the running of that part of it with signing checks, but I don't know anything about contracts. I'm not aware till when I ask a question or something is given to me. That is why these contracts here took so long. I did not know of them at the time. I was not made aware.
Mr. Albert may want to go through some of this with you, because that was also, I think you gave some evidence as well last time to the same effect. But just looking at the statute, and as I say, it may be that I'll need some further legal submissions on this in due course. But as I said, the structure is quite important. But 67(3)(e) is a really draconian and clearly a really draconian section, because if you are a director of a company which enters into a contract with the government, you must vacate your seat, full stop. Okay, so that's a really draconian section. Yes?
Commissioner?
And the only exemption is subsection 7. But under 3E, there's no reasonableness or whether you know about it or anything like that. It's if you happen to be a director of a company which enters into a contract with the government, you have to vacate your seat.
You not bring it at a reasonable time.
Okay.
If I may, I'd like to go off camera for about for brief.
No, not at the moment, Mr. Davis. Is this what you say may well be a matter for law, and I'll deal with that with Mr. Davis, and it may well be better to do that. But that's your understanding in any event.
Correct.
Okay. Now, Mr. Davis.
Sorry, it's just that my mother just recently had surgery and she's in town and she's not feeling too well. I have to carry her home. So I was just hoping we could go for lunch now or in a few minutes, and then I can bring her.
Okay. Mr. Davis, can we just stop the live stream while we deal with this?
Yes.
Already, off we go. Thank you. Just to let everybody know what's happening, Mr. Fliggleston Davis unfortunately has been called away urgently. He's likely to be away until about 12:30, and so I'm going to adjourn now until 12:30, particularly as there are one or two points of law which appear to be arising. It's important that he's here during Honourable Neville Smith's evidence. So we'll break now for about 25 minutes until 12:30. Thank you very much. I think we're ready to proceed. Thank you very much.
Thank you very much, Commissioner, for the bly.
Thank you. Mr. Howard.
Thank you, Commissioner. Honourable Smith, if we could continue. I think before we had to adjourn, we were dealing with the first potential criticism that was put to you. And can I just ask you, just take you through some of the documents relating to those two contracts, if I may. If you pick up the larger of the two bundles and turn to page 852.
Please.
852. This is the first of the two contracts that, which is the 26th of November 2020 contract. So I think you produced a similar document as something that you've exhibited to your bundle, but it's a 17th of January 2020 invitation from the government of the Virgin Islands to invite sealed bids for the installation of ICT equipment for the Royal Virgin Islands Police Force. Do you see that, sir?
Yes, I do.
And if you just turn through just to 854, those bids were due in by Tuesday, the 18th of February 2020. And as it turned out, Caribbean Security put in a bid and was successful in that bid. That's right, isn't it?
Correct.
And that's the subject of the contract that was then signed on the 26th of November 2020.
Correct.
But I imagine that given what you said earlier about to the Commissioner, that you stepped back from that company, you had no involvement in preparing the bid to this contract, is that right?
Correct.
And would it be fair to say that you may not even have been aware of the invitation to tender?
Correct.
I think if we're, again, in fairness, I just ask you to turn up 823, please, in the same bundle. This is the contract that we see there at 823. You can see the front page, and it's dated the 26th of November 2020. And can you confirm, for the purpose of the transcript, that 825, that the contract was signed by the Honourable Premier and Minister of Finance, Andrew Foy, but on behalf of Caribbean Security Limited, it was signed by your business partner, Mr. Dupree?
Correct.
If you could just turn up 787, please. It should be an email exchange, which you've provided, 787. And if you look at 786, please, Honourable Smith, if you see at the bottom there, there's an email from Mrs. Charlene de Brio Netzum, MBE, who is the Permanent Secretary of the Office of the Deputy Governor, at least at that time. And this is dated 22nd of June, 2021, addressed to you. And the subject is contracts executed with Caribbean Security Limited from 2019 to present. And would it be right that that what you did, Honourable Smith, was you were writing to the Deputy Governor's office to find out what contracts Caribbean Security had with the Deputy Governor?
Correct.
And was that inquiry made as a result of the correspondence that the Commission of Inquiry had sent you asking for disclosure of details.
Correct.
And the reply that Mrs. de Brio Letson sent to you, we see on 787, and she notified you of two contracts. A 2019 contract, which she told you was completed and paid in full, and the 2020 contract we've been looking at. Is that correct?
I'm noticing that they know, yes.
Yes. Your voice dropped a moment ago.
I'm noticing that they know, yes.
So would it be, again, fair to you to say that June 22nd of 2021 would have been the first notice you had that those two contracts existed?
Well, to be honest, I knew about the one, because only now, even going through this email, I realized there's two she said they had. I knew of the one,
Right.
because I hope, yes.
Break it down, please. So June 22nd, 2021, you're notified of
Of the contracts.
of two contracts.
Right.
Well, before that date, which did you know of?
The bigger one,
The November 2020 contract.
right, because that's when I started asking the speaker to see if I can get this to the house. So I thought about it.
Yeah, let's slow it down a little bit.
Okay.
So June 22nd, 2021 is the first time you say you knew of the 6th of December 2019 contract. Is that right?
When?
So if you look at the date of the email at the bottom there, you'll see that it's sent on the 22nd of June at 2:32. And so you have notification of two contracts, a 2019 contract, which we'll look at in a bit more detail in due course. But the 2019 contract, was that the first time you knew of the existence of that contract?
The first contract,
Yes.
I was aware, that's why I brought it up. I was aware of it and I was trying to get to the house from in January. The second contract that you're talking about now that I'm seeing here, to be honest, I even didn't realize there was a second contract after you brought it to my attention and the last thing as well.
Okay. So now we may be slightly at odds in that I'm calling the first contract the 2019 contract and the second contract the November 2020 contract, because in Mrs. de Brio Letson's email, the 2019 contract appears first. So if we call it the 2019 contract, when did you first become aware of that? Was it this email that drew it to your attention?
That's the one, okay, that's the first contract. Referring to now?
Let's call it the 2019 contract.
Okay. The first I'm aware of it is when you send it. I even did not notice it on this email.
I see.
Right.
So I followed. So you didn't pick it up from this email.
No, I did not.
It was after we drew it to your attention.
Correct.
Can I return to that, please?
Correct.
The 26th of November 2020 contract, was this email the first time that you were aware of that contract? That's the bigger one.
That's the bigger one.
Yes.
Repeat the question again.
So the bigger contract, which is the one that we're looking at under potential criticism 1,
Right,
is a contract essentially to install ICT on behalf of the Royal Virgin Islands Police Force. It is, as you rightly say, a bigger contract because it's just short of $100,000.
Correct.
And you had made an inquiry with the Deputy Governor's office. You had a reply back on the 22nd of June 2021, which notified you that one of the contracts that was still open was the police, which Mrs. de Brio Letson describes as the police ICT project, which is the 26th of November 2020 contract. So my question is, was this email from the Deputy Governor's office the first time you were really aware that this contract existed?
No.
When did you first become aware of its existence?
Around January 2020.
2020?
2021.
Yes, because it's a November 2020.
When I first heard about it, I came to the speaker and I told him I have a contract I may need to bring to the House of Assembly. That's when I first learned about it.
Right, but then take us back to before your conversation with the speaker though. So January 2021 is when you first become aware of this contract. How did you first become aware of it?
That one, I heard my business partner ask me a question. Why some about the contract with the police, and I asked him, well, what contract? And he told me, well, the one apparently we won the bid, but the work is not moving forward. If I know anything about it, why? And I said to him, no, I do not know why. Then I asked him, did the contract sign? He said, yes. I said, you cannot sign a contract. You have to come to the house first. So then I started to try to get it to come to the House of Assembly.
All right. So it was almost it was prompted by him asking you a question.
Right.
Almost he had a query about the contract, rather about contract performance, rather than him telling you, by the way, I've just signed a contract.
Correct.
And by the time you first knew of it, contract was already signed and work was being, or at least work, he was trying to get the work done.
Yes, actually trying to, the contract was already signed and he was trying to see what, no, I don't think the contract was signed when I first spoke to him. I'm not too sure. I don't want to lie about that.
Well, it was signed on the 26th of November, 2020.
So the meeting was already signed. Right, so when he spoke to me, he was asking me what's the hold up, if I knew why the hold up, and I asked him what contract. And then when he explained to me, oh, I forgot to tell you, I signed a contract for the police, we won the bid. That's when I first knew about the contract.
So prior to that conversation, did you know that he had submitted a bid?
The bid, yes, I knew bids were submitted.
Right. So you knew that on 18th of February 2020, he had submitted a bid?
Yes.
But sometime you think around January 2021 was when you learnt that the bid had been successful and the contract had been signed.
Correct.
I see. So I'll come back to your contact with the speaker when we go through your written response, if I may.
No problem.
Now, just before we leave the Royal Virgin Island Police Force, amongst the material that you have disclosed to the Commission are different types of invoices. So if you look at, please, page 810.
One,
810. So if you look first of all at 797. That's an invoice that from Caribbean Security Limited, addressed to the Financial Secretary and Ministry of Finance, and it gives the project name as Installation of ICT Equipment for the Royal Virgin Islands Police Force. So that invoice would appear to relate, would it not, to the contract that we've been looking at?
Correct.
But if you look at, for example, 810, it seems to be, if it says ICT camera project, is that the same project or is it a different project?
I can answer that question.
Can't answer it.
No.
All right. Well, try with 811, please. Because 811 is to replace physically broken door release. That appears to be for a completely different job, doesn't it?
Commissioner, like I said, I do not do the day-to-day. So these invoices I'm seeing here, I think I answer questions to them because I do not know most of them, to be honest with you. You'll have to actually speak to my business plan when it comes to those kind of stuff.
But the reason I asked the question is because these invoices aren't easily relatable to the contract that you're aware of.
if you want me to give you an insight how it actually operates, I could try to explain to you in terms of invoicing.
No, would you mind if I put my question first, and
Okay,
then
go ahead.
and then if hopefully we're on the same page,
Okay.
but if not, then we can take it another way. But there appears to be invoices that suggest that aside from that ICT contract, Caribbean Security Limited does other work for the police. And if it does other work for the police, then that raises the question, under what contractual terms is it doing that other work?
And then now to answer your question. How the company works, Caribbean Security is a company that installs, do services, do maintenance. So somebody let's say for instance, the police might have a door that's not working. And they may call a different company, and maybe that company cannot get it fixed or didn't show up. Then they may call Caribbean Security Limited. I won't know those calls. But then if they call them, we don't have a service contract with them, but it's on call. So if you call in, they may come out and fix the problem. Like for example, this door is not working and you need a technician to come and fix the door, because there's only 2-3 technical companies in the BVI that does electronic security. There's only 3 or 4. It's only a handful. So they may call the next available service that they can find to, hey, I have a door is not working. Can you come and look at it? And I think something like that invoice is where that may come from. Where they might ask somebody to come and look at something and they're going to fix the door. It's not a contract.
Well, how does it get paid? What's the process?
The process will be by a PO. They may give us a PO or something to say they want something done.
Right. So
it's not a contract.
I mean, your PO is a purchase order.
Yeah, mostly it might be a purchase out of the government.
But could they do things like that by way of works orders?
That I don't know.
If you look at 808, for example, that's a 2020 invoice, 28th of May 2020. It's billed directly to the Royal Virgin Island Police Force, and it appears to be for provision of various and installation of various bits of security equipment. I don't want to go in too much into some of the details of those invoices for reasons you'll appreciate, Honourable Smith. But that seems to be for a total bill at the bottom there of just under 8,000.
Watching this seemed to be part of the contract. Watching this from here, from what I'm seeing, maybe this is just equipments that came in, I'm not too sure. But watching it from here, from what I'm seeing, but then again, I don't want to assume, because like I said, I do not do the day-to-day running the companies. I cannot answer some of these questions you asked me on that.
So that's actually the best answer to give if you can't answer. A guess is sometimes worse. And so if you don't know what it relates to, please do say so.
No.
But if we, I won't give up entirely on going through the invoices with you.
No,
but if you can't help, do say. But if you look, Honourable Smith, at 798 in particular, you'll see there, again, it's a contract or an invoice directly to the Royal Virgin Island Police Force from Caribbean Security Limited. It's dated I think the 2nd of December 2020, if it's using the American formulation. But it refers there to an approved proposal. It's at the end of the top line. 11th or 10th of November 2020, approved proposal. So do you know, can you give any context as to how sort of an approved proposal is generated?
that I cannot answer as well.
Because if one pulls together the various invoices, and I've shown you some examples, you have work being done by Caribbean Security Limited for the Royal Virgin Island Police Force, which cannot be linked to that one contract we've looked at. And that does suggest the possibility, at least, that there could be other contracts other contracts, or B, other types of contractual arrangement that Caribbean Security Limited has, for example, directly with the police.
Commissioner, how I'll answer that question is, when I asked my business partner if we have any contracts at all with government, whatever contract you have with government, please send me whatever you have. Whatever you see me give you is what was there, contracts. I'm not too sure if this was not done as a contract, maybe it was done as a, which I don't understand why it would be done as if it was done as a proposal or bid. Can we normally ask more than one company, can you give me a proposal? Watching is the same proposal, I mean, the same invoice, but the number is the same proposal. It say paid, so it was something that was done, was paid for. But I'm not too sure whether this is involved in the contract, if it related to the contract or not. I cannot answer that. The only person I think can answer that question is my business partner.
In terms of two contracts were identified in the email from the Deputy Governor's Office.
Correct.
The 2019 one, the smaller one, 2021, the larger one. Where invoices are made in respect of those agreements, it seems to me that, as you'd expect, on the face of the invoice, that agreement is referred to. So on, for example, page 807, there's a reference on that invoice to the 2019 agreement. And we've seen another example of a reference of a first payment under the 2020 agreement. So it does seem, we'll come to the contractual arrangements later, but it does seem that Caribbean Security is doing quite a bit of work for the government for which it's being paid, not covered by those two contracts.
Commissioner, how I'll put that, in terms of work being done before, existing contracts with government before I was elected, there might be contracts that were existed before then. And what might happen is some of these things you might see, whereas they might call you in to upgrade or fix something. So I don't think that will go in as a contract. It will be continued based on what I had. That's the only way I could see something like that happening if there's already a contract already existed. So it just means that you go in and they might say, hey, look, we need to upgrade this. Okay, I won't have a bid for that because I've already existed in a contract with him. But like I said, due to what I'm seeing here, I do not recall, because like I said, I do not do the day-to-day. So I do not recall whether or not we have other contracts with the police or not. I really do not know that. I mean, you could question me all day on this. I cannot give you the answers you may be looking. I'll be honest with that.
Can you answer this question? We've heard evidence from others, both public officials and ministers, as to how suppliers of goods and services are paid mechanically, right. And they're paid by as a result of purchase orders. So, in respect of these payments, would there have been purchase orders?
That I'm not too sure of. It all depends. I say, again, it all depends. Like, for example, Caribbean Security does a service, monitoring and maintenance along with a contract. Once a contract is signed with Caribbean Security, that I can recall and I remember, what happens is you have a standard contract, states that we will do the monitoring and we will do the service. So once you sign the base contract, that's already embedded in that. So where you might see contracts here or something saying paying for maintenance contract, say paying for monitoring contract, is based on the first contract. And it's a continuous something of monitoring station and maintenance.
So some of these payments may be in respect of contracts that predated your election.
Yes, a lot of those are there. A lot of those. Most of them that you see in there. It's always a continuation of the contract in terms of service and monitoring.
If you go to 60, please, in the smaller bundle, Honourable Smith.
60.
Sorry, 61, please.
Yes.
We're back to the resolution number 11 of 2021, which deals with this contract in relation to the ICT equipment for the police. Contract dated the 26th day of November 2021. So you've explained that I think January 2021 is when you first become aware of the existence of a contract.
Give me correct it. Something like that, if I give the correct.
Around 2021, yes. Around January 2021, I think. Would that be a fair way of setting out your recollection?
Something like that.
So, and then it obviously ends up in front of the House in July 2021.
Correct.
How did you notify the House of the existence of the contract?
Commissioner, since I'm in the House and since I've been sitting next to the clerk and close to the speaker, I made it a practice that once I know something is there, I'm going to speak to both of them and say, hey, look, I know I have something to come to the House. When I need to get it on paper. But there was nothing put in writing. And that I have changed since the last time. I've made an arrangement where now, once I'm bringing something, I was sending my email saying I have something just to keep a personal record instead of word of mouth. Because at this time now being here, I realize that word of mouth is not appropriate.
So 2019, we've gone through, that was word of mouth.
Word of mouth.
What about this one?
This one here?
Yeah. Was that word of mouth again?
Which one? This one is no. Is this the last one?
Yeah, this is the one that you put your affidavit. So this is, this is the contract where you've told us you find out about it around January 2021.
That was word of mouth.
Right. So you just did it all by word of mouth,
yes.
And without an audit trail.
Correct.
So was it just you've mentioned speaking to the clerk and speaking to the honourable speaker?
Right. Correct.
Was that the sum total of what you did?
Right, I spoke to both of them, asked them. I also spoke to the AG. I had conversation with the former AG, the past AG as well, because also it was a touchy topic because of the content of what the contract was in terms of the police. So I asked a lot of questions as well because security is supposed to be security, not too much information getting out there. And I asked questions, is this something we should bring to the House? Or is this something we should maybe go to the National Security Council with? Because what they're asking here is stuff that could get me in trouble. Because if somebody found out certain things about this contract, I'm a target. And that's one of the reasons why I said certain things should not be even disclosed when it comes to the security part, especially with the police. And that is why there was a back and forth with the speaker, with the clerk, with the AG, with this here.
But nothing in writing, all spoken.
Nothing in writing, but you could, to my evidence, there's evidence there that I spoke to the speaker. The AG is not here. The clerk is there. She didn't give written evidence, but she's willing to come and testify if she has to as well. Mr. Commissioner.
Thank you. Let's move on to the second contract that's the subject of criticism one. If you turn up in the larger bundle now, please. Honourable Smith, just turn to page 509. Oh, sorry. Hang on. Give me one moment. Yes, it is. It is the right page. It's a page at the top there. You can see that it's headed proposal. So what appears to have happened, and this is as you go through the successive pages through to 519, Caribbean Security around June I think, yeah, no, I'm sorry, I'm not using the American nomenclature. Around October 2020, you see the date on the document headed proposal, put in a proposal for work in relation to installing security equipment in the telephone services management unit, the inland revenue, the treasury, etc. Can you assist the Commissioner with this? How did that come about, that proposal was put in?
Once again, I can answer that question. Like I say, I do not,
You were not aware of it?
Commissioner, like I said in all my statements, I mean, I'm being truthful about this. When I said, after being elected, I choose to not play any part in any of my companies just for transparency. I did it because I did not want to be compromised. So I take myself away. The only thing I did not do is take my name off of the companies, but I pull myself away from the companies. I have no deed to the runners of any of the companies.
So on that basis, just to confirm for the record, you were not aware that this proposal was submitted by Caribbean Security Limited in October 2020?
I'll be honest, I was aware of that because not then, but I learned about it after.
How long is a little bit?
I don't want to lie. Because the only reason I know about this is because I think it's when I saw a check. It's when I think my wife was making a deposit and I passed by and I saw a check from government and I took it up and I read it. That's how I knew that this was actually being paid out.
Right, so that would have been, if you turn to 508, site of that check, we'll see that at 508, the Ministry of Finance respond to Caribbean Security Limited to confirm that the quotation dated 6th of October 2020 has been accepted with the price of $72,917.56 as quoted. And then it says the projects unit will communicate with you regarding execution of the contract and other related matters. Now that would, you only became aware of this after you actually started getting paid on the contract. Is that right?
Basically, yeah. When I did find out about it, as I found out about it, I tried to bring it to the house. That's what I did, as I found out about that.
But can you give a date as to when you found out about it?
Can't remember.
You can't
honestly can't remember the date, no.
Now that, as we've seen, and we don't need to look it up, but that's the subject of the other resolution that came before the House. Well, let's turn up your response, please, just so that we can get that on the record. Some of what you say in that response, Honourable Smith, you touched on already, so it's important that we're fair to you, but I'm just going to briefly summarise it, if I may, and if you need to add detail, I'm sure you will. If we go to page 3, what you say there, and this is in relation to those two resolutions. Firstly, that you refute the criticism made. You say that although you are a director of Caribbean Security Limited, you're not involved in its day-to-day operations. You have had, as you say at the bottom there, a limited role for over 10 years, and it's limited to occasionally signing checks and making deposits. You don't correspond with clients, including government departments or individuals, with respect to any services provided by that company. You don't, and you are not provided with copies of contracts or notification of each contract entered into by Caribbean Security. And you then produce the letter, and you've mentioned this, but it's at your tab 1, a letter from Mr. Dupree, dated the 8th of September 2021, addressed to the Commission. And it summarises your, or his, if you like, he sets out this. I think I ought to just read it out.
No problem.
But the purpose, it reads as follows. The purpose of this letter is to shed some light on the day-to-day operations of Caribbean Security and responsibilities of the principals. It is a fact, since the inception of the company almost 20 years ago, I, David Dupree, have been responsible for those operations. This is the agreement Neville and I had as part of the company's establishment. Neville made it very clear that he was enthusiastic about our endeavour. However, due to his full-time responsibilities at Harney's, he did not have the time to be involved other than when necessary. According, from sales to installation, repairs to billing, all of these have been my responsibility. I would either perform these myself or, in the case of installation and service, to schedule our service technicians. Neville on occasion made deposits and signs checks when I was unable to do so. Furthermore, from time to time we would speak and I would inform him in general how the company was doing. Our relationship works, and there has never been a reason for me to report to him other than an overview from time to time. I've never informed him of ongoing sales efforts or sales themselves except in passing. It's just not the way the business is run. In respect to any contracts, the review and signing also have always fallen within my responsibilities. However, on occasion, prior to Neville's election, he would sign if I was unavailable. Since his election, has been kept completely out of this process. And that is a letter which is notarized and which, as I've said, you've produced to the Commissioner. Now, Mr. Dupree says that you've effectively not been involved in the company since its inception. He gives that as 20 years. Right. You yourself say that your role was limited, or became more limited about 10 years ago.
Right.
Can you explain the difference in recollection to the Commissioner?
Sure, Commissioner. Since I've been working with Hanny Western Regals, what happened is that my job had more responsibilities as well in Hanny's. And I could not have performed the duties that I would have loved to do in terms of certain things like sales and stuff like that. So Dave took over all of that. So I had nothing to do with looking for new jobs and nothing like that. And coming on to election, I pulled myself completely away from dealing with anything with the company, unless it had to be whereas signing his work permit and the other workers' work permits. But in terms of making deposits, I haven't been doing the deposits as well. I haven't been doing the checks. I merely just sign a bundle of checks. And when he requests information to checks for salaries and stuff, it is done by my wife, not me.
The question was slightly different, Honourable Smith, because it's just that Mr. Dupree says you've not been involved in the business for 20 years. You say you've not been involved in the business. Your role has been limited for over 10 years. It was just, could you explain why you came up with 10 and he came up with 20? Well,
as I said, he considered to be 20 because of the mere role I play. I considered to be, I still was playing a role, sort of, to me. I mean, he had it that way because that's what we said that we'll do. But I still was involved in a way, more than he may have known in terms of speaking to other clients and trying to get business. But yes, he played a role. So when he said that my role was not for 20 years, he can't say that. From the light and exception that we discussed, yes, I'm not involved. He's the one involved in companies. I send people to him. I will not make decisions on the company behalf for over 20 years. He will be the one to make the remarks and say, hey, look, this is what we're doing. What's not being informed. But I was not the one to go out there and say, hey, look, this is what we're doing in between the clients. I never met with the clients for over 20 years. He's the one who met with the clients. So that's why he said that.
On all of the invoices, there are hundreds of invoices here from Caribbean Security. On all of them, and also on the proposal that we've just looked at from October 2020, your mobile phone numbers on the proposal invoice.
I am part of the company. I did not take my name off of the company. So yes, my name remain on the company.
No, it's not in a formal way. It's got
the phone number,
office,
right?
Neville, call Neville cell, and your number.
Yes, it's on there because it has been on there from inception. We didn't take it off.
Right.
If somebody called me, I send them, I either tell them call Adrian or call Dave.
Yes, thank you.
Right.
Mr. Dupree, in his letter that we've read out, explained that your minimal involvement was because of your full-time role at Harney's. What was your role at Harney's?
At Harney's, I wear many hats. Let's put it that way. I started off as an accountant doing accounts in part of Harney. And then I turned to doing incorporations. And then I was dealing with liquidations and insolvencies. And my last role was a manager of doing operations, dealing with company searches, dealing with premises and stuff like that as a manager.
And you were full-time at Harney's for 20 years?
30 years.
30 years.
Exactly.
And do you find it somewhat troubling that if we look at the bigger contract, Mr. Dupree enters into a contract with part of the government or with the government of the Virgin Islands for just under $100,000, and he doesn't tell you about it?
It is troublesome because upon election, I also told my business partner that once you get any contracts or you're signing for contracts, let me know because I will have to ask for exemption. But you see, the thing about it is the nature of him and me not being involved in politics before. I don't know if he understood the role that he had to play now by getting contracts to me to bring to the House. I don't know if he understood the impact of it, which of late I even told him from here in, I made changes that from here in, any contracts that come to government, do not sign them. They must come to me first because I have to bring them to the House Assembly. I have been telling him so now, almost every time we speak, that's why I say to him, any contract you get, you have to bring it to me. So I've made the changes to make sure that I could fix that so it won't happen again. Because it's two things can happen. I either take my name off a company or I have to now play a more important role of make sure that when a contract is done, that I'm aware of it.
And which option have you chosen to do?
To make sure I'm aware of it. Because I consider that as a young man, I build what I have from time as a young man, and to now take it and give it away, or just say, hey, look, because of politics, I'm going to take my name off a company. I see that as being wrong because I work hard to achieve what I achieve in life. And what I achieve, I want to make sure that my children could benefit, my family could benefit from it. And I don't want to take a chance when I remove my name from my company, something happens and they lose that thought. I have no problem make sure that it comes to the House on time because we as young people here in the BVI, we work hard to get where we are. And I've done good to achieve what I have achieved, and I don't want to lose it because, I did something wrong. So I have to make sure I keep my eyes on that.
If we go back to your written response, we're on page 4 now, Honourable Smith. What you say, and again, I'm going to summarise, but you say that you have been transparent and honest in your dealings. You point to the evidence that you gave to the Commissioner on the last occasion that you were here. And you also make the point that the contract that we were looking at, the November 2020 contract, went through a tender procurement process. Why is the fact that it went through a tender procurement process relevant to whether you need to get an exemption or not? Commissioner,
like I said, here in the BVI, people have a tendency of, when they see you getting work, and especially they have politicians as corrupt. Everybody look at, that's over the wall, as corrupt. And if something not goes through a tender, the first thing people are going to say is, because you were in government, it was handed to you. If you understand. I mean, so being a tender, I bring it to show that it was a process in place. It was nothing that was handed down to me or the company. There was a process that took place. There were bidders, and the person who had the lowest bid, or not even the lowest bid, or who maybe had the best system is who got the contract.
The next point you make in response to this potential criticism is that you say that as soon as you became aware, you made the appropriate application, and what you say, and I'll set it out. I have requested a resolution and motion from the clerk and the Speaker of the House for an exemption on contracts entered into by by Caribbean Security Limited with government departments as soon as was reasonably practicable. And you make the point that the timing of when any motion is heard is not within your power.
Correct.
You've produced a letter from the Honourable Speaker. Now, that's your tab 3. Thank you. Before I go further with that letter, Honourable Smith, it is stamped at the top confidential. Well, you shrug your shoulders, but is there any issue with the Commissioner having access to that document?
To read it now?
Well,
I have the problem.
No, but it's the fact that it emanates from the Speaker's office. It's stamped confidential. So, and it's although it's addressed to us, but is there any issue about it being part of the evidence?
No, it's not.
Right. Well, let's see what the Honourable Speaker wrote.
I'm sorry, Mr. Howard, just before we do, in terms of these motions, the motion is brought by the Premier.
I'm assuming so because I think the Premier is the one who will have to bring the motion.
Yes.
I think, yes.
So how mechanically does it work? The Premier's office draws up. I mean, how does it work? Just mechanically, just generally.
How I know it to work is that when I go to the clerk or to the Speaker, they will contact the Attorney General's office and they will make up the resolution. Then I think what happen is it will be done by the Speaker to get an order paper, but I think he'll have to speak to the Premier. Okay, I think only him can bring that motion because I cannot bring the motion.
I think the Premier brings all of the motions.
So I think that's what happens.
Yes. So the mechanics, as far as you're concerned, is you speak to the Speaker,
Right.
Stroke clerk of the House,
Yes.
but you speak to them. They then instruct the Attorney General to
Correct.
draft the motion,
Correct.
and then that motion goes really to the Premier to.
It goes on the order paper and then I guess it goes by the Premier.
Yes. Yes. Thank you. Thank you, Mr. Rowan.
Thank you. All right, well, let's put it on the record then. On the 9th of September 2021, the Honourable Speaker wrote as follows, and it's addressed to the Commissioner, and it then continues. This letter is to confirm that the Honourable Neville A. Smith brought to my attention a contract he signed in November of 2020 with the Government of the Virgin Islands. The member on 4 occasions between January 2021 and June 2021 came to me asking that the declaration be placed on the order of the day. While I had every intention to place the declaration on the order of the day, I somehow allowed other issues of the House to take precedent over this very important matter, and I take responsibility for the omission. In addition, the 9th and 10th sittings were going on for a long time, and I allowed the questions posed from the opposition to take priority. It was not, and the Speaker has bolded the word not. It was not the member's fault, as he does not formulate the agenda. The House of Assembly agenda is a collaboration between the Speaker, the Leader of Government Business, and the Clerk. In addition, most often when requests are made, we still must wait on the Attorney General's chambers to respond to requests. That can take weeks most often. And the letter concludes, please be guided accordingly. So that's, I think, the second sort of piece of additional material you've provided to the Commissioner. Now it speaks to the November 2020 contract. But just help us a little further in relation to the April 2021 contract. When did you first raise that?
April 21. Which one is that now?
The one that we've been looking at in relation to
one for,
for the inland revenue, etc.
I think when I learned about that, I raised. I think as I learned about it, I raised it right away. Can't remember the date, but when I did learn of it, I brought it up as well.
But I think you said that this. I think this was the letter that you was this one that was brought to your attention by the COI, and then you took it forward.
The one that was brought to my attention by the COI is the last one.
Right.
Yes, you can do that now.
The one that we're looking at. That's another criticism. So we'll
Okay.
come back to that.
All right.
That's the one that you recognise.
That's the one that when you brought it, I didn't know. That I didn't know nothing about till when you brought it to me.
Just so that we can be clear and you can have an opportunity to answer this. In terms of getting these two resolutions in 2021, in July 2021, was your actions in any way motivated by the requests that were coming from the COI for disclosure of what contracts you had with government?
I'll say no. I'll say no, because when I learn of them is when I try to move forward, nothing to do with the COI. Because like I said before, and I've said this to the commission before, if there's one thing about me and what I try to do is I try to be on the right side and live by the book and be as transparent as possible. I always try that no matter what I do in terms of even where I started to work from Hannies. So when I know stuff, I'll bring them. Once I'm aware, I will bring whatever I could bring.
Let's go on to that, the contract that we did bring to your attention. So again, so that we can have the chronology in mind, if you look at in the larger file, please, at 812. So that's the first page of the contract. It's stamped, I think, by the Registrar's Office as December the 9th, 2019. If you look at the next page, please, Honourable Smith, you'll see that the contract is between the Government of the Virgin Islands and it's for a sum of $15,980.24. If you go through to 821, it's signed by Mr. Dupree and by the Honourable Premier. Now, I think the date of that, I think, was supposed to be August 2019. But if we go to 787, back to 787. We see that the date of the contract was given by Mrs. Debrio Letsom as 6th of December 2019, and you were told in there that it was paid in full. But I think your position was that actually that that just slipped through, and you didn't pick up on that existence of that contract at all.
Yes.
So it's sometime after June 2020 that you. So let's put it this way, as of 22nd of June 2021, you weren't aware of the existence of this contract?
I was only aware of the contract actually when I went to the lawyers to go over the what I had to go over, and they brought it again to my attention.
I see.
And I said to them, I already submitted this already. I already submitted this, because it's same police. So I keep looking at it as the same, I guess because it's the same police contract. I look at it as the same contract, and they're not going to the entirety. At the same time, I called my business partner at that same given time in front of my lawyer. And I asked Dave, do you know of any other contract decided with regards to the police? He said, no. I said, are you sure? He said, you requested whatever you want from whatever you needed, and I gave you everything, Neville. This is all it had. I said, well, Dave, you need to check again, because I'm here watching something with a contract number so for the police. So you need to look into it. He went back, he checked, he came back and said, I only have one contract for the police. I said, check again, Dave. He went back, he checked, he came back and said, I don't want to use the word. And said,
he spoke frankly to you.
And said, I made a mistake. Yes, I find it. This has been filed through the crack. I'm sorry, Neville, I'm sorry. I said, I can't do it. Sorry, you know, cut it, but it's already happened. And I have made, since then, I have made things to get it to the House of Assembly as well.
Can I come back to that, please,
Sure.
Honourable Smith, because I quite like to take things in an orderly sequence, and so we'll come back to your written response in a moment. What I ought to put on the record, which I haven't done, is what the nature of the potential criticism that we're talking about, which is criticism number 2.
Sure.
And that is that Caribbean Security Limited entered into a contract dated 6th of December 2019 for the sum of $15,980.24 with the government of the Virgin Islands to purchase and install items for the Royal Virgin Islands Police. On the available evidence, it appears that Honourable Neville Smith failed to obtain an exemption from vacating his seat as an elected member of the House of Assembly under Section 67 of the Constitution in respect of this contract. The Honourable Neville Smith acted contrary to and/or was in breach of Section 67 of the Constitution. Now, we've established that certainly June 2021, you weren't aware of it. So this warning letter is dated the 6th of September 2021. Was that when you became aware of it?
Correct.
So it was when you had to meet with your legal representatives to discuss your response to this warning letter.
Correct.
That you first became aware of it.
Correct.
Had you appreciated that the Commission of Inquiry was able to formulate a potential criticism because you had in fact disclosed documents relating to this contract to the Commission?
Yes, I understand. And the thing about it, I give you the information, not knowing that it even was in this bungalow. This is what I'm saying. So if I knew that this was here, I'd have reacted from then. So it's clearly aware that I even wasn't aware of that.
So you did, to be fair, hand over a large quantity of paper. So somewhere in there was a 15 grand contract with the police.
Exactly.
All right, let's put your written response on the record, please. If we go to page 5 of that written response. Again, Honourable Smith, I will just summarise it because you make same points as you did in relation to criticism 1, which is that although you're a director, you're not involved in the day-to-day. That's left to Mr. Dupree, and you repeat what limited role you have, and that for the it's limited down to, as you say, signing checks and making deposits. And in relation to this contract, you say this: unfortunately, as I'm not involved in the daily operations of the company, it appears that this contract fell through the cracks, and I was not notified of the contract dated 6 December 2019 entered into by the company until recently. Upon receipt of the invoices and receipts from my business partner to provide to the COI, I further inquired with my business partner on the contract referred to on the invoice to the Royal Virgin Islands Police Force. I've recently received confirmation of the existence of the contract, and as such, I've made arrangements to seek a Section 67 exemption in relation to it. You then conclude that you will continue to always act with honesty and transparency, and once I'm made aware of the contracts entered into by Caribbean Security Government Departments, I will make the relevant declarations, seek consultation or legal advice from the Attorney General, and request a resolution and motion in accordance with Section 67(7) of the Constitution as soon as reasonably practicable. Now, if we break that down, the stage we've got to is that, I think on your evidence, June 2021, when you have the email from the Deputy Governor's Office, you just did not pick up the point that was made to you that there was a 2019 contract.
Correct.
When you received all and collated all of the documentary material that you provided to the Commissioner, which I think was in July 2021, and I'll be corrected if that's wrong, but oh, yes, the 20th of July 2021, you provided that. you also were not aware of it.
Correct.
But then when you received the warning letter from the Commission, dated the 6th of September 2021, that's when you, that's the first time that
I was really made aware of what it is. Because, like I said, because the fact that it was the same police, I keep just thinking that that's the same police contract and stuff like that. So that's what happened. I wasn't even looking at the figure. I was just like, this contract, I don't do this already. So it was a simple, really oversight.
Just explain to the Commissioner that you say you've taken steps to get a resolution. Just what steps have you taken?
Well, what I've done is I spoke to the clerk and the speaker again to get it on the other paper, which it is on the other paper for tomorrow. And I think in that way, I think I made a request actually writing this time.
So you have an email where you wrote to.
I think I did. My secretary sent something. I had my secretary do it via email or something like that. So I should have something on that now, because I have decided to, going forward, to make a paper trail of these events.
If the Commissioner thinks it's necessary, would you be willing to provide that email to the Commission?
I don't see no problem in that. I could ask my secretary to find it and try to get it to you.
Thank you.
I don't see a problem.
You're accept the distinction you're now drawing between statutory boards and government, but 3 years into your time as a member of the House of Assembly, you have now benefited from 4 resolutions of the House in relation to Section 67. Tomorrow, I'm not going to predict the outcome, but you might benefit from a 5th. That's probably quite a good strike rate in terms of getting resolutions in relation to Section 67. Have you taken any, or what steps have you taken to put in a system for Mr. Dupree or others in the other enterprises in which you're involved to alert you to new contracts?
Well, what I've done, it's not in writing to what I said, but what I've done, I told Dave, maybe I have to draft something, and maybe he might need to send something maybe to the government itself. I might have to send a letter to the government itself saying that any contracts that Caribbean Security enter to, that from here in, it comes to me first. So I might have to put something like that in place so that at least it triggers the force in me before it goes to him. So I think that's something, and I'm always open for opinions as well, because that's the only way I could see it working. Whereas I trigger that from government saying any contracts enter into Caribbean Security, it must come to, I don't want to be the one to sign them, to be honest, but I would like to be notified of them. So, because if you realize with these contracts here, most of these contracts, apparently what would happen, they were not sent to me, they were sent straight to New York, to Mr. Dupree. So that's why I was not aware of them. And most of them were like, please sign and get back as soon as possible because you want the work done right away. So I think that's where the hiccup came. So if I created it, whereas it must come to me first, not for signing, but at least for proofing. At least I could see it and I know it's there. Then, because the thing about it, I still have to bring the contracts to the House of Assembly to give to the AG to make the resolution. Because I can't, and that's one I hold up again, I cannot make a resolution until I get a copy of what the content of the contract is as well. Because they need to see where it's from.
But no system in place yet?
To get, well, not to the government, but to,
to anybody.
To Dave, to my partner, yes. I told him plain enough from now on, don't sign any more contracts. Example of that, right now there's work pending on a contract that cannot be signed. Because the contract, he brought it to me and I have it. I cannot sign it because it was sent to the House. But every time we try to get it to the House, it's not happening. Because we keep extending the House, it was not on it. So it's on this other paper now. So I have made changes, whereas any contract from government must come to me first with him, and he accepted that.
Because looking backwards, you certainly your time as a member of the House of Assembly, you know, there have been a number of contracts that you were not aware of.
Correct.
And to take this example, this one you only became aware of because the COI wrote to you.
Correct.
How can you be sure that no other contracts have fallen through the cracks?
That I cannot say yes yet to, but based on the information that he sent, I think the other country you would have picked it up.
So you're hoping that the
I'm just
COI
saying,
won't write you another letter?
No, I'm saying at least for now, from what the past, I could say that apparently you went through where they say it was picked up. But from here in, I will make sure that any contracts that are being signed must come through me first. So I'm just talking about what's gone now from 20, because if someone was, because what I give you here is all the invoices that was done since I was elected. So if it's something else was there, you would have found it.
But have you yourself done, it's not just Caribbean Security, have you yourself done an audit of the documentation relating to all your interests to confirm for yourself or to be confident that there isn't a contract with government that Caribbean Security have or Frontline Systems may have that you haven't declared to the House?
What I've done is I try to collectively go back in my memory and remember, especially with Frontline, because the Frontline is an individual entity. I went back and I checked and see what I have with that. In terms of any other companies, contract-wise, there's no contracts. Caribbean Security is the only company that mostly deals with government because of what it relates in terms of contracts, in terms of business-wise, in terms of, let's say, security, because of what we do. The other companies that deal with government may be like POs, like selling paper, but not a contract. So that I can remember for sure. But the only one I know for sure, yeah, probably I think is Caribbean Security, because the extent of business that we do is where I see that happening.
Because I mean, it presents difficulties for you, Mr. Smith, I'm going to suggest, because if you don't know what the company's doing, how can you fulfill your role as a managing director?
Let's put it this way. When the company started, and we started a company in inception, this company was started based on trust, based on what I want to see in the BVI in terms of security, in terms of what was happening and how to help other people. The company did not start off to come to where it grew to now today. I never in my life ever thought of being in politics, never, because I never intended to be in politics. But because of me being a trustworthy person and people see me as somebody they could trust and who try to help other people, I end up getting involved in politics. Coming here, I didn't know that I would be faced with stuff like this. And I wasn't prepared for it. And now that I'm here, I'm trying to make sure that I do the right thing. So by saying that I don't know what's going on, I won't say I don't know what's going on. My company was based, and we grew on trust. We grew a relationship. Me and my business partner, we became like best friends. There was two other partners, one died, one passed, God rest his soul. And we grew a relationship after trust and after the relationship that we had doing business with other people. So it's a trust, something that we have and we had. And we still have today. And I could say, ain't much company might have that trusting relationship with their business partner, but I have that with him. So I trust him. It might be worked that way at some place in the world, but I know the one that I have is trustworthy.
I think that it may have been my question, but the point is that you are the managing director of that company. You've spoken about your wish to, if you like, preserve your legacy for your children. You've spoken about how you came into politics, but leaving your House of Assembly hat to one side, you are still the managing director of the company. And the question was really, you must have a role as a managing director of a company. And how can you fulfill that role if you don't actually know what the company's up to?
Well, I depend on my partner at times that when we do meet, he'll give me suggestions and I give him suggestions when we do meet and when we decide to have any kind of meetings. Like I said, the company was based on trust and relationship. At this point in time now, I think I'm open for recommendations, one. And ways maybe I need to take my name off as a director and maybe put it on as something else. and not director, because stating on the constitution is stating director and it's, I think, shareholders as well. So my question, I have to start to ask a lawyer, how else or what else can I do with my name? Whether I can put it in trust or something, put it in a different company, I'll have to find out. But my thing that I have, when I listen to some people saying what I should do and say, put it in your daughter's name, put it in your father's name, put it in your mother's name, to me, it's still the same. Whether it's my mother's name or my father's name or my sister's name, I'm related to those people. So I still have an interest in the company. So we have to find a way that we could fix that. Because to me, that is not an answer. Because if I put it in my daughter's name, I still have a say.
But there's a fundamental or an overarching issue here, and that is the issue really of conflicts of interest. Under section 67 of the Constitution, once you become an elected member, the general rule is no contracting with the government as an individual or as a member of a firm or as a director. Full stop. That is the general rule, and it's very clear. The exceptions, and I accept that section 67(7) is not drafted as clearly as it might be, but the exceptions are that before you enter into a contract, you get the House of Assembly's approval if they consider it to be just. But when you say, well, you know, there are ways that we might be able to get around this by me becoming something else in the company other than a director, but still having a part in the company, or transferring it to a close relation who would effectively look after it for me while I'm in politics, it doesn't seem to me really to address the fundamental issue here. And the fundamental issue here is the potential conflict of interest between an elected member and contracts with the government. There is a fundamental conflict of interest there, and that's the thing that section 67 is designed to address.
So, Commissioner, if I may.
Yes.
So are you saying to me, if I'm reading it wrong, I mean, I'll have to ask advice, that a private citizen who have a business should not do, and once that person came into government, doing business with government before, should give up those businesses?
No, but
no accent.
I'm not saying that. But under section 67, the general rule is no, and it's up to the House of Assembly before the event to say that in certain circumstances it is just to allow you to trade with the government. It might be just for, I mean, this is only an example. It's a matter for the House, as long as the conditions of section 67 are complied with. They may consider it just if, for example, you have a long-standing trading relationship with the government. They may, I don't know, it's a matter for them. But it's all done beforehand. It's not done, if I might say so, in the way that it's been done here, which has been in less than an optimal way. And I don't say that it's all on your shoulders. The Speaker says the Attorney General sometimes takes a long time to draft the declarations, and he has taken, he has shouldered the delay in part of 6 months in getting a declaration through the House after you had spoken to him, as he accepts. But looking at it from a governance point of view and conflicts of interest, this does not look to me to be a system that is working as it should be. I'm leaving aside whether you've committed any infringement of section 67, but this is not how it should work.
Okay.
Commissioner, I'm going to ask for a break. Before I do, can I just ask one more question of Honourable Smith, because we can then move on to a different topic, and it's this, Honourable Smith, and I should have asked it earlier. But you'll remember that you explained to the Commission that your discovery of the sort of November 2020 contract, the big police contract, was because Dave Dupree contacted you.
No, because what I did, the same letter you see, I asked the The same email that that was sent to Deputy Governor Office, I asked the question as well.
Yes,
Right. I asked for a copy of the contract because I knew after I learned about it. I even asked, as I asked him, he have a copy. He said he didn't have a copy. So I asked the Deputy Governor Office, they could fund me with any copy that we have.
Yeah.
Actually, I did it to every government entity.
So you, I see. So if I break that down, so following inquiries made of you by the COI, you then contacted every government entity and said, Caribbean Security, what contracts do they have with you?
Caribbean Security, Frontline, what contract that any one of the entities have with you?
Now, but as I understood your evidence, and we saw the email to the Deputy Government Office's June, you were saying that big police contract you knew of in January 2021, and you knew of it because Dave contacted you.
Asked me a question.
And he asked you a question, and that's what prompts my question, because you're in elected politics, you've stepped away from your companies and your businesses. In relation to Caribbean Security, you've not been involved at all. So why would Dave ask you a question?
Because he thought that that's something that government will know, why the contract, if the contract was awarded to somebody, because he wondered if it was already awarded. So he thought, or I heard something that was awarded to someone. So he was asking me if it was awarded because we already changed the mind. I said, well, there's not me, it's under the Deputy Governor's Office. It's not government. That was under the Deputy Governor's Office. So when he told me that, that's when I was prompted about it as well.
But that was after the contract had been
signed. Yes, because I didn't know when it was assigned.
But he couldn't have, I'm sorry, he couldn't have rung you after the contract had been signed to ask you whether the contract had been awarded to Caribbean.
Because what happened, the same as if what happened, the contract was signed, but nothing was happening. Nobody was saying anything. So he thought it was just scrap, it was finished because it went quiet. So that's what I came from.
So he wanted to know really about the implementation of the contract.
Yeah, he wanted what's going on.
If the works were going to be done, right? Yes.
Because if you look at page 797 in the bundle, you appear to have been paid on the contract, or Caribbean Security Limited appeared to have been paid on the contract.
I would know that. Remember, in
December.
But I wouldn't know that. You want to explain?
No, but Dave would.
Right.
Again, I'm sorry to interrupt. But also, you say he contacted you in January to see whether the contract was still live, and if Caribbean had been paid, there may have been less interest in knowing whether the contract was still live. Payment is really quite important for a supplier.
Commissioner, I can't answer the question where he felt the way he felt.
Yeah.
That he felt he had to call me and ask me that question. I don't know why, but he did, and I say that's what even prompted me even more with it.
Yes. So thank you.
Commissioner, I'm going to move on to a different topic, so perhaps we could have a short break. Or
yes, we need to have a break in any event for the stenographer. Are we moving on to section 66?
We're moving on to criticism 3, which is still, I think, section 67. Right. But then we'll move on to section 66.
I was just thinking about the length of break to have. We need to have a break anyway for the stenographer. He only needs, though, 5 minutes. Would a 20-minute break be sensible? We'll break for 20 minutes and then we'll come back at 2:30. Thank you very much, Honourable Smith. Oh, I'm sorry. Just before you cut the link, I said I'd come back to Miss Peaty about whether I might want to hear from on behalf of the AG in terms of the law. I think at the moment, Ms. Peaty, the answer is yes, I would, particularly on section 67(7). Ms. Rowett, any observations on that?
No, but as you've noted also, I think Mr. Davis wishes to make submissions anyway.
Yes, Mr. Davis wants to make some oral submissions anyway, which I'll hear at the end of the evidence. But section 67(7) at the moment seems to be, in my mind, seems to be something that I will want to hear from both Mr. Figgleson Davis and on behalf of the Attorney General at the end of the evidence.
I know this is always difficult, but might it be possible for Mr. Rawat to give us a heads up as he thinks he's coming towards the end of the evidence? Because I will need to find and extract Sir Geoffrey so that he can attend on time.
You think what do you need? Half an hour? Is half an hour?
I think half an hour would do it.
What we'll do is we will give you at least half an hour. Mr. Rawat will give us an indication, but in any event, you will have your half an hour.
Thank you. Appreciate that.
Good. Thank you very much. 2:30. Thank you. Good. We're ready to resume. Mr. Rowett.
Thank you, Commissioner. Honourable Smith, thank you for returning. We're now on potential criticism 3. And before we deal with it further, can I just put the criticism or encapsulate it on the record? It is that Caribbean Security Limited entered into a contract with the BVI Ports Authority dated 22nd of September 2020 for the sum of $39,000. I'm going to read that again. For the sum of $39,350 to purchase and install items for the authority. On the available evidence, it appears that the Honourable Neville Smith has not been exempted from vacating his seat as an elected member of the House of Assembly under Section 67 of the Constitution in respect of this contract. Honourable Neville Smith acted contrary to and or is in breach of Section 67 of the Constitution. Now, if we just look, please, at the large bundle, I think it will be at 703, please, Honourable Smith. Just before we turn to your written response, just set some of the background to this contract, please. What we have is at the very bottom of the page, it is, and I'm going to be a little careful about referring to specifics as we go through this, as we have been doing throughout, but we have from Vance Lewis, who I understand, tell me if I'm wrong, but is the CEO of Tortola Pier. Is that right? Correct. And it's dated July 15, 2020. It's addressed to you, actual GovVG address, but also CCing Dave Dupree, your partner. And it asks you, it's addressed, Dear Mr. Smith, and it asks you to provide a quotation in response to certain specifications which are attached to the email. And it would suggest, it continues, I would suggest that you or your business partner come to TPP to understand location, runs, etc. Now, do you often use your government email account to conduct private business?
Commissioner, my email address, I do not use for Caribbean Security, but somebody know that I'm in government, they will send me something there, yes.
You say somebody knows you're in government, they will send you
If they
something.
know I'm there, how to reach me, and there's only address they have, they will send it to that address.
In relation to Caribbean Security or in relation to other private matters?
Anything. That's the only address I use at the moment.
So both, is that you're saying, is that the only email you have active at the moment?
That's what I use at the moment, right?
I see. So,
Yes.
so you get, as well as emails concerning your public functions, you might receive emails that relate to your private affairs on that address.
At times, I sure.
But even if that is right, and you're using, that's your one email address now, if you're not active in Caribbean Security and you've never been active, you certainly on your evidence haven't been active for since March 2019 at all. Mm-hmm. Why are you getting emails concerning Caribbean Security?
Commissioner, once again, everybody who knows me knows that I am in Caribbean Security Limited. If somebody have a question for Caribbean Security who knows I was David, they will contact me. In return, what I'll do, I'll get that information to David Dupree.
Now, there's an invitation in this email to come to TPP, and Mr. Dupree, I think, is based in the US, isn't he?
Correct.
So given that he was based, and we can see that July 2020, obviously nobody could be traveling around anywhere.
Correct.
Did you attend TPP to discuss locations?
No, I did not.
Now, if we go to 699, please. In fact, if you go to, yes, 696, please. Right. What we have is this is a sort of exchange of emails between Dave Dupree and the Ports Authority concerning the contract, and its details in who has to sign the contract. And what the Executive Secretary writes to Mr. Dupree is that he could sign it even though he was overseas. But then it continues, in this particular circumstance, it may be best for Mr. Smith to sign because the contract is in a very simple format, does not include signing in counterparts and relying on copies, etc. The previous contract was signed by Mr. Smith, so we will proceed along those lines. And can you just help, the reference to the previous contract, what is that to?
That might mean that something before elections that we did some sort of work over there maybe, and I signed that contract. There's a possibility that what that would mean.
Well, it's a contract that you're said to have signed, but other than saying it might relate to something that happened before the election, can you? I'm not sure if it's before.
No, I'm not sure it's before or during. I'm not sure it's before the election or not. But we had other contracts with Port Authority. So that's what they're referring to, because we did other contracts with Port Authority before that I knew about.
Right, so that you were aware of other contracts with Ports Authority and you had signed other contracts?
Correct.
If you go then to 683, that's the contract itself, and that's the first page of it. And if we go over, you can see that it says at the top that it's made on the 22nd day of September 2020, and at page 691, you can see it as well on 688, first of all. You signed the contract for and on behalf of Caribbean Security.
Correct.
And then it was notarized by a commissioner, or certified by a commissioner of oaths at 691. Now that's that contract in November 2020. If you could just turn to page 744, please. This is an invoice dated 13th of September 2019, and it's in the standard Caribbean Security Limited template. So it's as the Commissioner pointed out, it carries both your cell and Neville's cell number. Sorry, your cell number and Dave's cell number. But what it refers to is work being charged to the Ports Authority. If you go back, Honourable Smith, to 719, working back through 719 and working back to 707, you'll see that there are more invoices to the Ports Authority. This one at 719 is for an annual service. You then have at 718 inspection of a system. Again at 717 we have another annual service. Again at 716 an annual service. 715 monitoring of a system. And these, it appears, I don't want to read out the details, but it appears that Caribbean Security Limited are doing different things at different port locations.
Correct.
And then if we look an example again at 714 of a door release not working. Then if we go through again at 712, you have monitoring of the system, which is it's written as a particular price of $100 per month, billed quarterly in advance. So it seems to be on a rolling basis. Now, this is all invoices in 2019,
Correct.
covering sort of right through, if we look at 707 through to December 2019. Now, those are obviously not part of that contract that we've just looked at. So in what context do those invoices arise?
Those are contract based on, those are invoices that were based on contracts before election. The contracts to do monitoring and maintenance of existing contracts that we had before I was elected. So that's where that's from.
Using the Ports Authority as the example, then, is the way that Caribbean Security work is that you will come in and you might install a system of a security system to the client specification,
right?
And then you will offer also a monitoring and servicing.
Okay, Commissioner, let me break it down for you. Basically, how it works. If I'm given a contract, or let's say it's not a contract, let's say even if we bid on a job and it's not really a contract, they say they want to hire us, it's not much, but let's say a door. I'll use example, this building. When we give you that contract, the contract is outlined, what are we installing? And there's also a part showing you what the monthly cost will be for monitoring, if it's a burglar alarm or a fire alarm. If it's a CCTV, it will only be a yearly, because that does not include monitoring, so it's only be yearly. If it's a burglar alarm, is monitoring and service. Every entity have a service contract. So if it's burg, keyless entry, fire, or video, is a maintenance contract for those. But only fire and burg is a monitoring contract because they're being monitored. When they sign the original contract, there's on the bottom of the proposal, it states, once agreed to this contract, you're also buying to the monitoring and to the maintenance. That means you accept it. So once you accept it, it's a contract until you break the contract. If you do not want it, you will not sign that. Then we will not monitor or we will not maintenance. That's how it works.
Thank you, that's helpful. So if we look at what was going on in 2020 then, so if we look at 742, please, Smith. Again, we've then got examples of the same monitoring stroke maintenance contracts rolling over into 2020.
Correct.
And I don't need to sort of go them at length, but they cover the points that you have just made to the Commissioner. So at 746, we see a reference to burglar alarm monitoring, 747 to fire alarm monitoring. But if we go to, please, to 748, we don't need to give the detail of this. It's about access to a building, it seems. But it refers, do you see, to approved proposal, and then it gives a reference number. So again, in the context of the Ports Authority, how do those approved proposals arise? Again,
Commissioner, once you have existing contract, once it's in the same building, like for instance, use as an example, let's say they want to add 2 more smoke detectors, maybe a police station. They will request us to come and look at that. And then they'll get an invoice for that. It won't be a contract because it's existing already. They just add on to what they have. That's how they will arrive.
Right. But the reference to approved proposal suggests that they you make a proposal for work and they approve it.
Agree.
You then do it and they then pay you.
Yes, Commissioner.
Which from your perspective must be the most important part.
not really.
But those are those kind of approved proposals. Do they come up in the work that Caribbean Security do with a range of clients?
Yes, Commissioner. If I may add, Commissioner, based on what you're asking me as well, yes, other companies, we do that as well too. But you see what happened is, sometimes you might have a system in your building and you may decide to put a partition off in the building. So therefore, using security code, using the code, fire code, you might have to come and make adjustments to the system. And what happened then, we'll come in, we'll give them a proposal. This is where the proposal comes from, saying that this is what it costs to do that. They could either accept it or they could refuse it. And then most likely the building might be out of code, but that would be up to them if they want to do that.
I see. I see. So if they want to stay within the law, they will have to. It's up to them. If they want to stay within the law, they'll have to.
Correct. And to the Commission, that's not just government. That is with every company that we do security for.
Well, we see another example now, and we're moving into 2021 at 758, please. This seems quite it's an approved proposal which relates to let's call it network connection, because I think thereafter it's what might be described properly as matters for the technical folk. But you see that the price of this was just over $8,000. And this is from the 15th of April 2021. So it's obviously not the contract that we've been looking at. Correct. So it's described as an approved proposal, but something like this, which is $8,000 plus. I mean, how is it? Can you assist the Commissioner with understanding the mechanics of how it's contractually? How does the process work?
To the Commissioner, what will happen is that they will actually. I'm speaking of what I knew in the past. I don't know if anything has changed, like I said, but based on how it was before and how it operates. What will happen is that Port Authority will contact Caribbean Security and say, hey, look, we have a building we want to secure. We are seeking proposals, not just from you, from different companies as well. And like I said, there's only maybe 4 or 3 security companies in the BVI that does what I do. So when that happens, one of the technicians from Caribbean Security will go across. It doesn't have to be David Dupree, and that's why I even bring it up, because I realized in part of the document, I realized that we said either me or David Dupree to visit the site. It doesn't have to be David Dupree or myself. It could be any one of my technicians that we had. So a technician will go, look at the site, come back, make all the different notes, and pass it to David Dupree, who will then in turn create the proposal. I will not see the proposal either at this moment, but it will be created and it will be sent to the Port Authority, and Port Authority will then call us and let us know whether or not we were accepted or they choose somebody else. It was never that it was given to us by saying, hey, give me a proposal, you have the job. It always had competitive bidding as well.
Let's, as in this case, you got the job, the proposal was approved.
Right.
In terms of the mechanics of what do they send you? I mean, what do they give you to show that they're going to, what's the documentation so that you can get paid on?
That I do not know. I can't remember how that works in terms of the mechanics behind their scene, but I know we send a proposal and then the Moselle turn might say you were accepted, and they might give us a down payment for the job. That's why we call supposed to happen. In terms of a PO with port authorities, I don't know of such.
Taking it outside the Port Authority, then we've seen that you can do approved proposal work for others. Generally, what happens? You put in an entity has approved the proposal, you're ready to do the work.
Right.
What's the next piece of paper in the chain?
The next piece of paper will happen. They'll send us a letter saying your job was approved. The same contract. Because we drop our own contracts based on that. They will sign the contract and say the job is approved. Here's your 50% down payment. Can work commence whatever date you want. Now that's how that's done. Even from private entities, you give a proposal. If they accept the proposal, they call you back and say, yes, yeah, the approval has been accepted. When can you start? You could come and sign the contract. You go, you sign the contract. They make a down payment. The material is being ordered. Once we get a down payment, we order the material. We could tell them when we could commence work. We could start. Most likely, the company normally have most of the material at hand because we always keep stock inventory. So they could start the project. So by the time the material is shipped, we're already ahead in the project.
But using this as an example, this sort of distinct job,
right,
that's an approved proposal, what you need before you want to put your service technicians there.
A signed proposal. Once I get a signed contract.
Yes, that's what you want. You want them to say to you,
accepted.
And we're really talking about, obviously for today, Honourable Smith, about how government bodies work. But what you want them to do is to say, we accept your proposal, here is the contract, sign it.
Right.
And then also what you want them to give you is a down payment.
Sometimes not. I must say sometimes not. Depends that you have a steady relationship with the client. You may proceed without the down payment.
And I think what can be said of Caribbean security, and this is something we might come to a little bit later, is you have got established relationships with quite a few government entities.
And private.
And private.
Thank you.
Let's turn to your written response, please. Just so that we can deal with that, so that it's on the record. I think this takes us to your page 7, Honourable Smith. So,
yes.
Again, I'm going to summarise, if I may. The Commission will, of course, read the entirety of the response, but in summary, what you say is that you signed the contract, and you recall signing the contract dated the 22nd of September 2020 on behalf of Caribbean Security Limited. At the request of Mr. Dupree, because of his inability at the time to sign on behalf of the company. But you importantly perhaps make the point that the BVI Ports Authority, being a statutory board, your position and your understanding is that you do not have to seek an exemption because statutory boards are not part of government.
Correct.
And you've explained to the Commissioner earlier today that the backlash that you received when you sought an exemption in relation to what was said to be statutory boards back in 2019 has caused you to shift your position, and your position is now if companies in which you have an interest contract with a statutory board, you won't be seeking an extension on that basis.
If I could comment more on that, I mean, I shouldn't say I will not seek, but I'll find some other way of getting it done, because if I'm not asked, if I'm told not to bring it to the house because it was in the house time, I don't want to take it to the house. So I'll have to find, and I'm always looking for opinions and maybe other ways that I could get that done. But
it's not difficult to publicise that. It's not difficult to publicise the fact that you have a contract.
It's not difficult, but are you saying to me, Commissioner, that every time I get a contract for a statutory board, I should make it public?
You're saying to me that that's what you propose to do.
Well, what I'm saying is, no, I'm not proposing to do that. That's why I'm running from, because I'm saying, because it seems as if it's a small place here in the BVI, and it seems as if every time you get a job or a contract, and because of the kind of stuff that I'm dealing with security, I have to be very cautious as how I put information out there, because I'm in breach as a security company. Once I start putting information out there to the public, I will be in breach, because I'm set, like, for example, I'm securing your home. If I put in the newspaper, I'm securing your home, I'm making you a target and me a target, because if I have the codes for your house, which I will have, I will contact me to get them. I could hold Neville as hostage and get those. So we have to look at the context and look at what we're talking about, the element of what we're dealing with here, which is security. I understand the whole room and what we have now, but we have to take this into serious context, that security is a risk assessment, is a trust something, and is also something that is held in terms of protecting people's lives.
I understand that. I understand all of that, and I see the force of them, those points. But in respect of contract with the government, you have the obligation under Section 67.
Correct.
In a sense, you don't have any choice there. You have to get a declaration in proper form from the House of Assembly. In relation to statutory boards, you got exemptions in 2019 in respect of 2 contracts, knowing that you didn't need the exemption, but the Speaker and the Premier clearly thought it was not inappropriate for you to obtain an exemption that you didn't need. You decided, because of the response to that, not to do that again. And your view is, and I see the force of it, no need to get an exemption. But you say that you're now considering doing that in some other way. That's all I was exploring.
Right, and I'm open for opinions on that, Commissioner. If there's other ways that can be done, I'm very much open for opinions as well.
Okay, thank you very much.
And I think what can also be said, Honourable Smith, is that in relation to the resolutions that you obtained in 2021, which both related to Caribbean security, you found a way to, or a way was found to describe the nature of the contract without compromising security.
Commissioner, I don't think so. Because when it go into debate, a lot have been said in the debate as well. I caution the government side and my side that, please be careful how this is being discussed in the House, because it cannot reveal certain stuff. But the fact that it even came out that, here it is, I have a contract for putting up around the BVI, that was a breach.
In your view? In
my view, because now anybody who wants to know where point A is or point B is, who are they going to look at?
So that's another conflict of interest. Yes, thank you, Mr. Rowley.
If I may say, this is a conflict of interest, but I find it not this is a conflict of interest, because even if I'm not a government entity, it should not be said. So even I'm not a government, even if I wasn't in government, what I'm trying to say, that's something that should not be revealed.
But if you weren't in government, you wouldn't have the obligation under Section 67. That's why there's a conflict of interest. Okay. If you're just a trader and you do some, as it were, provide some service, or really it's a service, provide some service that's confidential, Right. But under Section 67, it's not that straightforward if you're in the House of Assembly, because that requires you to disclose something. And I appreciate that there are difficulties, but the difficulties arise because of the potential conflict of interest.
Gotcha.
Yes, thank you.
I want to move on to the fourth potential criticism that was raised in the letter, please, Honourable Smith. And I'm going to just put it into the record. It's this. Honourable Neville Smith published 2 declarations of interest in the Island Sun newspaper on 2nd and 9th February 2019, prior to the 2019 election, which took place on 25th of February 2019, in purported compliance with Section 66 of the Constitution. The declarations in both publications were in identical terms and stated. And what's then set out, and we'll look at the declarations themselves, but what the wording that you used in the Island Sun newspaper. What then also is said is that the affidavit, which is the affidavit that you provided to the commissioner at an earlier stage, which I think was on the 16th of August 2021, that confirms that your business stroke companies had a business relationship with the government prior to your election. And that's not something you dispute at all, is it?
No.
The potential criticism that's set out in the letter continues as follows. On the available evidence, it appears, 1, from Honourable Neville Smith's disclosure to the COI on 20th of July 2021, and his affidavit dated 16th of August 2021, his businesses had entered into contracts, whether via contracts, petty contracts, work orders, and/or purchase orders, with the BVI government prior to his election as a member of the House of Assembly in 2019. 2, in particular, that Caribbean Security Limited entered into a contract dated 16th of November 2018 with the BVI government to provide services and supply/install items in the sum of $43,000. This contract was extant at the time of the Honourable Neville Smith's election in 2019. In the declarations, the Honourable Neville Smith failed to properly and/or at all set out the nature of the contracts his company / businesses had with the BVI government. Honourable Neville Smith acted contrary to and/or in breach of Section 66 of the Constitution. Now that's just that. Can I start off by just looking at the declarations themselves so that we remind ourselves of what they are? You'll find them, Honourable Smith, in the smaller bundle at 63 and 64. And they're in the same terms, Honourable Smith, so I'm just going to read out the declaration from the Island Sun of Saturday, the 2nd of February 2019. So under the heading Declaration of Interest, the notice reads as follows. I, Neville A. Smith, declare interest in the undermentioned companies. And you then list the companies as follows. 1, Caribbean Security Limited, and you identify your role in brackets as partner / managing director, and you say supplies, installs, and maintains security systems. 2, NS Cleaning and Imports, you identify your role as managing director, and you then say supplies, cleaning services, and products. 3, Frontline Sound System, where you identify yourself as the managing director and you say applies staging, sounds, promotion and entertainments, etc. 4, International Construction Limited, you identify yourself as managing director and you say it's building construction. 5, N and L Charters, you identify yourself as managing director and that deals with boat charters. And then number 6 is NS Water Services, where you identify yourself as the managing director, and that delivers provisioning and provides waste disposal. And 7 is NS Services. Again, you identify yourself as the managing director, and that supplies copy paper and office supplies. Correct. Now, and then it's recorded from signed Neville Smith. Now, before we go further, I just want to just examine a little the nature of the work that your various businesses have and have had with government. If we start off with perhaps frontline systems, as I've called it. Sometimes you've called it frontline sounds, sometimes frontline systems, but we'll adopt the second today. Now, we looked at the contracts that Frontline Systems had with the Festivals Committee. You've taken us to the 2 contracts that you've provided in your disclosure. If you go, please, on level into the larger file, Lever Arch file, and go to page 1104. 1104. So what we see at 1104, Honourable Smith, right through to 1110 are a series of invoices to the Ministry of Transportation, Works and Utilities. So the two entities that your disclosure shows that Frontline Systems dealt with are the Festival Committee, and am I right to say this, that the Carrot Bay Festival Committee and the Road Town Festival Committee just come under the umbrella of the Festivals and Fairs Committee?
Correct.
Thank you. So now what we've got is a separate entity, which is a government Ministry of Transportation, Works and Utilities. In relation to those invoices, can you help the Commissioner at all just to understand the how Frontline would have been contracted to do that work? These are invoices in October and November of 2020.
Commissioner, once again, I do not do the day-to-day runnings of Frontline as well. Let me make that noted. But what will happen is that somebody will contact Jason Fred, who is the person that deals with Frontline at this moment. If you see the signature, Jason Smith.
Yes.
And he will give them a proposal based on what they want, along with somebody else who will bid as well, small proposal like that. And they will be rewarded the job if it's within the realm that they want and the price that they want to pay.
So is it similar to the process that we outlined before, the whole approved proposal process?
Yes.
They'll contact
Jason, he do a proposal, and if they accept it, they'll tell him, okay, fine, we accept it, just like ports.
And so you then end up with a contract, you do the work.
You see, even a contract to me is a PO.
So this
It don't come as a contract.
So it's a purchase order.
Basically, I think it's like a purchase. It don't really be a contract as far as I recall. It don't be no contract draft with this. Yeah.
But for your own purposes, you will have an audit trail that says, yes, we accept your proposal.
I won't have that no, because as Jason deals with that.
Yes.
Yes.
I think
but to ensure that it was signed off,
yes,
like somebody accepted, yes.
Yes. I suppose when I was talking about the new, I was talking about Frontline Systems. Okay. So Frontline Systems will, before it does any of this work, will ensure that it has a written acceptance of the proposal, an agreement as to the price that's going to be paid, and then it gets paid for the job.
Correct.
So, and then you submit your invoice and you get paid. And are there occasions when you don't get your proposals accepted?
Correct.
And are there occasions when, depending on who you're dealing with, they might give you a down payment before you start the work?
Correct.
Thank you. Now, NS Cleaning and Imports is slightly more complicated for...
Before we get to the more complicated, can I just ask one question about this? You don't regard there as being any contract when Frontline Systems are engaged as you have described?
I consider it as a contract once it's over a certain amount of money, I guess, and they drop a contract. But once it's, for instance, we in this room here now, I always use this room, and you needed a PA system. And you know that Frontline System provides quality sounds. They may call and ask Jason, do you have a PA system that we could rent? And that's how we start.
And he would say yes.
He would say yes.
And how much it was.
Right.
I would accept that.
Right.
And then he'd come and there would be a contract, because if he didn't come or it didn't work, I could sue him. And if I rejected it at the door, he could sue me.
Well, you call it a contract. I mean, and there's a part of the document that actually was a contract. But
anyway, you don't regard what has been described as a contract for these purposes.
I do not call this a contract.
Okay.
That's what I mean. Yeah, we don't consider that to be a contract. That's how I look at it when it comes to that. I don't consider it to be a contract. I mean, well, I guess it's a contract. You sign an agreement to something that was a contract. Once you sign something, it's considered a contract legally.
It's a legally enforceable
agreement. I'm seeing what you're saying.
Yes.
Once you sign something, it's legally a contract. So I get where you're getting at and that.
But in any event, you do not treat these as a contract.
As a contract.
Okay.
NS cleaning imports, the best starting point, Honourable Smith, is to look at, and the reason is because I hope will become clear very shortly.
I can clear before you start. I think I know where you're getting at. You can have NS cleaning and paper, and selling paper, but have NS cleaning imports.
Oh,
You're getting that? That is the name of the company. The name of it is NS Cleaning and Imports, right?
yes.
But it doesn't clean. It
It,
sells paper.
right. Okay. Well. I'm sure it sells clean paper, so
You get a
that's
paper.
possibly some of the way. But let's start with the index to the bundle. If you go through the bundle, please, there's a section. It's the larger bundle. You'll need to open the larger bundle. Take it right back to the front, please, Honourable Smith. If you turn through the index to, there'll be a subheadings that says NS Cleaning and Imports. See, it's probably the last but one page.
The last, if you go to the very last page
Of the index.
which is just literally that's
Just turn over that page.
turn
Turn it back.
backwards.
Turn it back. You should see a heading that says Frontline Systems at the top, and underneath is NX Cleaning and Imports. Now, I hope it'll become clear why I've taken you here, first of all, because I mean, you've pointed out that what NS Cleaning and Imports does is sell paper. But what this index helpfully tells us is that you sell paper to the Department of Agriculture, the British Virgin Islands Ports Authority, the Complaints Commission, the Department of Education, the Department of IT, Elmore Stout High School, Facilities Department, House of Assembly, Immigration Department, Inland Revenue, then overleaf the Land Registry, the Ministry of Finance, the Ministry of Natural Resources and Labour, the Premier's Office, the Supreme Court Registry, and the Survey Department, Telephone Services, and the Treasury Department. And is that, is selling paper the sole sort of function of NS Cleaning and Imports?
Yes, it is.
Well, if we go to if we take an example, because what you have provided other is in terms of the documentation that relates to NS Cleaning and Imports is just a set of invoices, which all look pretty much the same. So if we go just to an example, let's take 1193, please, Honourable Smith. So just to explain for the transcript what it is, it's an invoice, and we're using it just as an example, but this one is billed to the Premier's Office. It's dated the 24th of November 2020. And we see that the invoice is for 3 units of copy paper at $58 per unit. And then there's you're also invoicing for 3 units of copy paper at $75 per unit, and then 1 unit of copy paper at $75 a unit. And that's replicated throughout these invoices. The common price that is invoiced is $58 for a unit of copy paper. Now, what this looks like is that NS Cleaning and Imports provide copy paper across a range of government departments.
Commissioner, this has been done for way before I was elected as well. So it's just a continuation. It's nothing new that any of them are new. Actually, half of them is now not existing anymore. But yes, it was done before. All this was being done before elected. Established was already with them already.
This is pre-2019 as an arrangement, but can you help the Commissioner with what is the nature of the arrangement?
Commissioner, I want to say there's an arrangement. What happened is most companies and even government, everybody shop around for the best price when it comes to stationery or paper, and also somebody who will deliver the paper. The company NS Cleaning, what it does, they sell some of the cheapest paper, and they also make delivery of the paper on time. You don't have to come and pick it up, we bring it to you. So what will happen is if any company, not just government, anyone want paper and they know of NS Cleaning Imports, they'll make a phone call and say, I'm requesting 6 cases of paper, 5 cases of paper. And in that, someone will deliver the paper to them. That's how that works.
But I mean, here we're looking at we were looking at the Premier's office. I mean,
Good.
Did you have a contract with the Premier's office to supply
I have
paper?
no contract with no government entity when it comes to paper. NS is just on a call basis. Somebody want paper and they make a phone call and we sell paper. That was always that way. Never established any contracts with government for paper.
So they would phone you up, say we need X number of units of paper.
Right.
What's the cost? You will tell them the cost.
Right.
They will say, right, we will pay that cost. Can you deliver it?
Correct.
And that was the arrangement.
That's the only arrangement I know about.
Thank you. If we turn to Caribbean security, which again, I think probably the best way to do this is to go back to the index, because it's the swiftest way of doing it, and just turn back to the first page of the index, please, Honourable Smith. The way the index has been organised, Honourable Smith, to explain to you, is that it's according to who was billed, basically, or who the contract was with. Okay. And so you have provided, and I hope we can establish that you've provided documents in relation to the work of Caribbean Security Limited that goes back 3 years, that covers 2019 through to 2021. That's right, isn't it?
Correct.
And the documents you've provided are a mix of contract details, email correspondence, invoices, as we've looked at. So what you have sought to do is this right, is to, once the COI put you on notice, to gather as much of the documentation as you could, and then to provide it to the COI.
Correct.
And if we see that it does show, does it not, that Caribbean Security Limited has had extensive contracts with government that, as you've explained, some of which will have relate to contracts that were put in place before you were elected to office?
Commissioner, the majority that you see here.
Yes.
That's how it is. They were put before.
That's a fair point, Honourable Smith, because as we've looked, we've identified the specific ones that perhaps can be said to have come after your election. But there, certainly what you were doing was contracting with government departments before you became an elected politician.
Correct.
And if we just go through the entities with which Caribbean Security Limited has done work, you have the Archives and Records Management Unit, the Attorney General's Chambers, BVI Airports Authority, BVI Health Services Authority, the Central Statistics Office, the Court Reporting Unit, the Department of Agriculture, BVI Electricity Corporation, Elmore Stout High School, Financial Investigation Agency, Financial Services Commission, Government Office Complex, HM Customs. There is then named a member of the House of Assembly, and there is then named a second member of the House of Assembly, Immigration Department, Inland Revenue, Magistrates Court, Ministry of Finance, Ministry of Sports, Ministry of Transportation and Works, Office of the Director of Public Prosecutions, Office of the House of Assembly, Ports Authority, Tortola Pier Park, which is the matter that we went into some detail earlier. The Public Works Department, the Royal Virgin Islands Police Force, which is again something that we've looked at. Social Development Department, the Supreme Court Registry, the Telecommunications Regulatory Commission, the Treasury Department, and Water and Sewerage. So that's shows the range of government entities that you've done work for. And I think, without descending into technicalities or specifics, as you've explained, the work that you do as Caribbean Security Limited spans the full range of the work that might be necessary in relation to a security system.
Correct.
And so you will install a system to the client specification.
Or design.
Or design. You will offer a monitoring and maintenance service.
Correct.
You will also, for I suppose, want of a better phrase, you sometimes will fix problems.
Correct.
I mean, we can pick anything at random, really. So, I mean, literally at random. If you go to page 627, please. And that's perhaps at the less sophisticated end of what work Caribbean Security Limited does. But we see that on the 14th of August 2020, one of your service technicians was called out because the speaker locked himself out of his office. Is that right?
Correct.
And that's an example of the sort of that might be something that you might have to do because of a maintenance contract.
Yes, as a security company, one of the first people you're going to call if something goes wrong is one of your maintenance guys.
I'd like to just look at some of the invoices with you in relation to Caribbean Security. I appreciate that what you've said about that you might not know some of the detail, but if you can help, I would be grateful. Could you turn up 371, please? Can I ask you, though, to do this, Honourable Smith? I'm going to be careful to avoid using people's names, and I hope you will be able to do the same. Now, and again, I'm also not going to refer to specifics. But what we see at 371, and if you look through to 375, this relates to the same individual. And if you go, for example, to 375 in particular, and indeed 374, what Caribbean Security were doing, and these invoices relate to work done at the end of 2020, seems to be installing security systems into the house of the private house of a member of the House of Assembly. You're nodding, but you need to say yes or no.
Yes, I'm not because I can explain it. That's why I'm nodding. Right.
And if we go to 377, again, please don't name names, but or indeed the detail. But we see at 377 and 378 that again in mid-2020 this time, the company is again installing a security system at the home of a different member of the House of Assembly.
Right.
If you go to 630, please. This is now work done by Caribbean Security Limited at the beginning of 2020. This is a third member of the House of Assembly. It's again their private home. And it's again, this is now an invoice that relates to maintenance of a system that's already been installed. Is that right?
Correct.
If we look at 631, we're looking again, this is beginning of 2020. This is again about, goes to the private residence of a member of the House of Assembly, but this is now an example of a monitoring invoice.
Correct.
And as the one we just looked at this is billed to the Office of the House of Assembly. If you turn please to 651, please, Honourable Smith. Again, this is now the invoice relating to a fourth member of the House of Assembly that we're looking at. This is a yearly service, essentially, an invoice for a yearly service of a system, obviously, that's already been installed. And this again is Caribbean Security Limited billing the House of Assembly. The reason for taking you to those is this is from the invoices, 4 examples of Caribbean Security having either installed a security system or maintaining or monitoring that system. And these systems are being installed in the private homes of members of the House of Assembly. Now, that cost, this is intended as a criticism of the amount that you charge or the work that the company does, but that cost has to come out of the House of Assembly budget, doesn't it?
Correct.
Do you can you say, and tell me if you can't, because these are all invoices of 2020, can you say whether that work is done on one contract or is it done in a different way?
It's basically, as I could recall, because I know we said when we talked about it, as I could recall, this is done to the House of Assembly. It's not done as individual members. The bill is to individual members, but it's to the House of Assembly.
Yes, so the House ultimately pays the cost.
Yes.
But has the House of Assembly contracted with Caribbean Security Limited to do this?
They already have existing contracts. So that's, again, is a continuation of what was going on.
I see. So you had in place a contract before you came into the House to deal with security systems at the private homes of members of the House of Assembly.
I won't put it that way. Well, it says that seeing that they already have existing contract with the House of Assembly, they just continue to use the one security company they have instead of going to 6 and 7 different security companies.
And you were the one security company they had.
Correct.
But do you or did you recognize, or do you recognize the potential for a conflict of interest here?
I would say no, because it was something that's been done with before. I mean, it's a continuation of something. If I just come into politics and it was not existing, I can understand that. But the fact that I already had a relationship with the House of Assembly before, I did not consider it as a conflict. That's my
of course. Yeah. Well, your answer is important, but the potential could manifest itself in this way, Honourable Smith. That you obviously, as a director of a company, you employ people, you have a business, you want your business to be successful, so you want to get the best price, and you want your company to be profitable.
Correct.
That's on the one hand. On the other hand, you are a member of the House of Assembly. You have to vote on budgets. You want to look for value for money, don't you?
Correct.
And those two desires, if you like, are where the conflict of interest could potentially arise. Would you accept that?
I'm not going to accept that. I understand what you're trying to say, but I'm not going to accept that because, like I said from the beginning, the prices that Caribbean Security may have done is based on what we do as a security company. It doesn't matter whether it's the Premier or whether it's me who we're doing a contract for. We have a base price based on what we're doing that we bid when we bid for prices. What we try to do is actually know that if it's a client that we already exists, we look at giving a better price because he already exists. But to say that because I'm in council, I mean, I'm in government, I will look at I think because of the budget, I know, well, we want to pay this price. I don't see those things. I am part of the House of Assembly, not the executive. So even when we get into the budget, yes, we may go, but I don't have a say in those things.
But I mean, there must be an element of the House, of the budget of government, right, that goes to the running of the House of Assembly, must there?
Correct.
And part of that budget, the House of Assembly has decided, and it's not a party political thing, but the House of Assembly has decided that some of that budget will be spent on security systems at the private homes of members of the House of Assembly. And isn't that where the potential tension arises? Because you vote on that budget.
No, I understand where you're trying to reach with it. So now I understand what you're saying. So go ahead.
So it's that tension between, as a member of the House of Assembly, wanting, as you must do, to get best value, but then on the other side, you obviously want your company to succeed. But
also remember, I am not in the day-to-day runnings of Caribbean Security, so I do not engage my business partner when it comes to negotiations. So I understand what you're getting at, but I do not negotiate with government or with no one in the business anymore. So I will not know what prices are being charged at this point.
Thank you. Could I turn to your written response to criticism 4, please, Honourable Smith, and that is at page 9 of 10. Commissioner, if it will help, this might be an opportune moment to just tell Miss Peaty that if she needs to extract Sir Geoffrey, now is the time to begin the extraction.
I think, sorry, I think he would be attending remotely, so I think he would be ready as soon as you and the Commissioner are ready, Mr. Rawat. So I don't know how long you think that will be.
That's a hard question to answer.
What we'll do, Ms. Peaty, because Mr. Rawat is unreliable in time estimates, or has been known to be. Can we say this, that once we finish the evidence, we'll see whether Sir Geoffrey is available immediately, and if not, we'll give you a few minutes to get him online. Yes.
Okay, thank you.
Again, if I can take it like this, Honourable Smith, you, as you have done with the other criticisms, you make clear that you refute the criticism. You point again to the limited role that you've played with Caribbean Security and over a number of years. You say that you're not involved, as you have done, to in its day-to-day operations, and point to the experience of your business partner, David Dupree, who lives in the United States and has over 40 years of experience in the security industry. You then say, and this is taking us back to section 66, you say this: however, prior to my election, I ensured that I briefly set out the nature of any contract which may have been entered into by Caribbean Security Limited and the government of the Virgin Islands in accordance with section 66 of the Constitution. It was my intention in the declarations in the Island Sun newspapers on 2nd and 9th of February to briefly set out the nature of the businesses. I clearly set out that the contract entered into by Caribbean Security Limited and the BVI government was to supply, install and maintain security systems. At the time, I was not aware of each contract entered into by the company. However, I was aware of the nature of services / contract which will be provided to the government of the Virgin Islands and my interest as director of the company, which was in accordance with section 66 of the Constitution. You then say that as a newly elected official, you had sought advice from members of the House of Assembly on the information required in the declarations of interest. And as such, my responses on the declaration was in line with my colleagues in the Island Sun newspaper on 9th of February. I'm going to pause there because I think what we need to do is to look at quickly the contract that is cited in the criticism, just so that we can take that through. So what we have, if we go to page 358 in that small bundle, please, Honourable Smith. That is a contract that is specifically mentioned in the criticism and drawn to your attention. It is between the Government of the Virgin Islands and Caribbean Security Limited, and it's stamped November 22nd, 2018. But we see, if we go to 359, that the contract is made on the 16th of November 2018. And if you go, please, Honourable Smith, to page 363, which is the tail end of the contract. We see there it's signed on behalf of the government by Dr. the Honourable D. Orlando Smith, Premier and Minister of Finance as he then was, and yourself giving your title then as manager. There were 3 payments made under this contract. If you go to 391, we will see that on the 21st of November 2018, payment was approved by the finance and planning officer of $30,284.55. That was the first one. Then at 397, in fact, let's take it 396. In March, there was a further payment of $25,827.65. And then if we go to 410, please, Honourable Smith.
410?
410, please.
Okay.
2nd of December 2020. The final payment under that contract, and again, that's the amount due then was $6,456.90. So that's, and the point of drawing that contract to your attention was obviously it's an example of a contract signed before you went into office, but then continuing as the potential criticism says into 2020. Now, you've addressed section 66. It might be worthwhile us looking at that and your obligations under it. If we go to page 35 in that small bundle, please.
Yeah.
66 says, it's headed disqualifications for elected membership. This is section 66 of the Constitution. And 66(1) records no person shall be qualified to be elected as a member of the House of Assembly who, and then it sets out various bases on which someone could be disqualified. And at F, a person can be disqualified who is a party to or a partner in a firm or a director or manager of a company which is a party to any contract with the government of the Virgin Islands for or on account of the public service, and has not, within 14 days before his or her nomination as a candidate for election, published in the Gazette or in a newspaper circulating in the Virgin Islands, a notice setting out the nature of the contract and his or her interest or the interest of such firm or company in it. So if we look at sections, you see, if we go back to your declarations, and we can use the if the copy of the Island Sun that you attach to your written response, because that's, I think in fairness, that's the one that you rely upon. And so if we look at it, what you have declared is interests in the undermentioned companies. But it's right, isn't it, Honourable Smith, that you don't set out there the nature of any contract with government.
That's correct.
You don't mention in your notice government of the Virgin Islands, do you?
That's correct, but can I explain?
Of course.
Commissioner, when I was asked to come and serve the people of the Virgin Islands, I was a private citizen doing business. Knew not much about the Constitution, but the full of the Constitution. I solely depended on others to explain who asked me to run, or who was running with, who was there before, how it works in terms of declaration and filing the stuff for declaration. So, Commissioner, I was told once you know you're doing business with government, in your list of companies, make sure you put them in newspaper. I was not told, even once was mentioned that you have to list a contract in the paper. I did not know of that. I'm sorry for my ignorance in it, but I did not know. So I only work off of what I was told to do by the committee. And plus, I mean, I find it strange though that the election office even didn't mention that, because I'm now getting into my third year. So it seemed as if this would have never been picked up.
I'm so, when you say that you were told what, who told you?
The senior member would have been the senior member would have been the premier at the time, because he was the only elected person at that time, because every one of us was new members coming to run for council. So we followed the guidance from him and from whoever was involved in political affairs before what to be filed. If you look at you notice the declaration of interest, most of us nearly did the same thing. I'm not too sure that other members have business with governments. I cannot vouch for them, but I know I have with government. But
I mean, some have put it in, some declarations are in the same form as yours,
right, but
not all of them. If you look at the one on the left of yours, I'm actually looking at the declaration of interests in your file. There's the declaration of interest by the Premier, Andrew Foy, and he certifies that he does not have any contract or business with the government of the Virgin Islands at present. That deals with a contract point. Right. And then he goes on to say, nonetheless, I hereby list all of my interests, businesses and companies, and he does so. So some of them, that's not unique. The one above him, Carvin Malone, at least refers to the fact that he's got contracts, but doesn't give the nature of them. So there is a variety. There's no consistency here.
Correct, Commissioner.
But but anyway, you sought advice from who did you seek advice from?
When we had political meetings and when we were told that we have to file this stuff, it was brought up in the meeting saying that this is what you need to do. You need to file all the companies that you have that are doing business with government. So therefore, I knew that my company is doing business with government. So I make sure I file every company that I knew, just in case. I said, let me don't take no chance. I filed every company that I know that I know doing business. I was not aware that I had to sign or put on that I have a contract 14 days before those. I was not aware of that.
So you didn't look at Section 66? I
did not. Like I said, because I was not in line with the Constitution, because I just started in politics. I never had reasons to really follow the Constitution to the entirety.
I mean, I understand that.
Yes.
And the Constitution's a relatively long document. But if you're seeking elected office, disqualification for elected membership, I don't say this pejoratively, but that might be one of the sections that you would look at.
I accept that now.
Yes. Thank you, Mr. Rowley.
Can I just ask Honourable Smith, just going back on one point, I was asking you questions about the arrangements in relation to security systems in the House of Assembly.
Right.
And you explained that, do you remember in the context I was exploring with you whether that prompted in your mind a conflict of interest? But you explained that that contract had begun before you came into the House of Assembly yourself.
Correct.
Just try and help us with how long is that contract set to run?
I will assume that will stop once the clerk or whoever decide that they want to use a different service. That's how I think it runs. If let's say, for instance, now that I ran for politics, if a different government get in, because I ran for politics, you may say, well, okay, he was with this government, so we don't want Caribbean security anymore. But I was also involved even before this government, the other government. So that's what I'm saying. It's not, that's why I didn't take it as a political, because when the other government was in, I also did that as well.
We've seen an example of that because of the signature, but it's just that specific. I mean, there is a contract to provide security systems for the House of Assembly, which encompasses the security systems in the private home of members of the House. That contract, you say, it's obviously started before 2019. The question was, when is it due to end?
I think the response is that Honourable Neville Smith will correct me if I'm wrong. It's for an indeterminate period. It's open-ended.
It seems that way to me because once the clerk or the speaker decide that it doesn't exist anymore, because once, I think how it's laid out, once you're already doing the work in the House of Assembly, as you have used a security person for the House of Assembly, I think this is how it is taken the context. Because I'm doing work with the House of Assembly as a security person, they might then want to venture out to get a different security company. Actually, they know who you have and what you're doing, and they use me to do that. That's how I look at it. I mean, I can't get up and say, well, that's why then, but I'll assume it's because you want to keep it with one company. You try to stick with one company.
And is that the case for most of the contracts that you had with arms of government before 2019?
Commissioner, if I must say, if you're doing a good service and you're doing a good service when it comes to security, people will keep you. And I think that's the same thing, just what you said. I think that is it. The fact that I was doing things with them before and they were happy with what they had, they continue.
But in terms of this one company, you've got other companies dealing with other arms of government. Mr. Rowett pointed out to the index where the contracts are listed. There are over 30 arms of government. Even that there were 30 contracts was not something disclosed in the notice.
Correct.
Okay, thank you.
Commissioner, if I could have just one moment.
Yes, certainly.
Commissioner, I've reached the end of my question, but before I forget, could I ask Honourable Smith, or just remind him, he may recall earlier that we asked if he could produce some email correspondence. I think the best way will be that what we'll do is we'll write to him through his legal representative, setting out what correspondence we'd invite him to disclose to the COI.
Commissioner, can I make one correction though? I said email, but apparently my secretary is not an email, it was a letter that she drafted.
A letter to the Deputy Governor's office.
Not the Deputy Governor's office. The letter was to you're talking about the letter that I did to the clerk and to the speaker?
Oh yes, you're quite right. You're quite right. That was the first thing. It says, as what I can't promise Honourable Smith is that we won't add to the homework list. So there may be a couple more requests, but for correspondence. But we will write to your legal representative, setting out what we need.
I will try my best to give you whatever I'm requesting. I have no problem with it. Thank you.
No, thank you very much.
Thank you. Can I conclude by thanking you, Honourable Smith, and thank you not only for coming today, but also for the way that you've assisted the Commission.
No, thank you very much. Can I echo that? Thank you for your patience and the way you've given your evidence in such a clear manner. Thank you very much.
Thank you very much.
I'm now going to hear submissions from Mr. Flickleton Davis and from Sir Geoffrey Cox. They're on section 66 and 67. You can stay or go as you wish, but stay there if you wish to stay there.
I'd like to hear it.
Yes.
Commissioner, but if I could, before we do, just ask you to rise for 5 minutes. I think we've just still got to wait for Sir Geoffrey.
No, I'll do that, and we'll get Sir Geoffrey Cox linked in, Miss Petey, and then as soon as that happens, we'll continue. Yes? Good. Thank you very much. we're ready to resume, and we have Sir Geoffrey Cox online. Sir Geoffrey, can you hear and see us?
I can see you, sir. Can you hear me?
Yes, thank you. And we can see you. Thank you for coming online. Sir Geoffrey, I've reserved any legal submissions until the end of the evidence, and we've finished Honourable Neville Smith's evidence. Firstly, I've done this already when you were not online, but I thank whoever drafted the submissions. There is no name other than Withers on them, on section 66 and 67, because they were very useful. And certainly from my point of view, I think Mr. Fliggleston-Davies wants to make some more submissions on some other points. But the only thing which is causing me concern is the proper construction of section 67(7). And what I'd suggest is, in particular because Sir Geoffrey is representing the attorney, I hear from Sir Geoffrey first, Mr. Fliggleston-Davies, and then perhaps you next. I'm not cutting you out from making any other legal submissions, but all I'm focusing on is section 67(7). But I'll be glad to hear any submissions on any other points you want to add to the written submissions I've received from you and from on behalf of the Attorney General. And then Mr. Rabbit perhaps can make any observations that he would like to make.
So Commissioner, I in the ordinary course of things, Sir Geoffrey Cox would have to go first anyways, being a much senior attorney to me.
Well, that's true, but he's going first today because I would like him to go first. So Geoffrey, can I just run through section 67(7) with you to explain where I would like some assistance. We've got to start, obviously, with section 67, subsection 3, which reads that any elected member of the House of Assembly shall vacate his or her seat in the House, subject to subsection 7, which we'll come back to, if he or she becomes a party to any contract with the government or the Virgin Islands, or for or on account of the public service, or if any firm in which he or she is a partner, or any company of which he or she is a director or manager, becomes a party to such contract if he or she becomes a partner in a firm or a director or manager of a company which is party to such a contract. So there it is. It's mandatory. You have to vacate your seat if you fall within 67(3)(e), subject to subsection 7. And subsection 7 reads, if in the circumstances it appears just to the House of Assembly to do so, pausing there, that means that the House has got a discretion if they have jurisdiction. The House may exempt any elected member from vacating his or her seat under subsection 3(e). If, so there's a condition, such member, comma, before becoming a party to such contract as there described, pausing there, that's one way in which the condition can be satisfied. And secondly, or before or as soon as practicable after becoming otherwise interested in such contract, whether as a partner in a firm or director or manager of a company, whatever that means, that is the second way in which you can satisfy the condition. Discloses to the House the nature of such contract and his or her interest or interest of any such firm or company in it. The first way in which the condition can be satisfied, that is, before becoming a party to such contract, seems to me to be self-explanatory. Where I would like some assistance is what is meant by or before or as soon as practicable after becoming otherwise interested in such a contract. What does that mean?
Well, I'd like to return, Commissioner, good question. The truth is that one has to wrestle with language that by nature has a degree of imprecision. But I take it that it's all of that phrase that you wish assistance with. So if one were to seize the words first, as soon as practicable, it's difficult to make submissions on that. And they're ones with which you will be, the nature of any appropriate submission, you will be more well aware of. I mean, it's clearly a matter we would submit on the question of as soon as practicable to the House, which has a judgment to make on the specific facts of the notice and the circumstances surrounding it as to whether it has been as soon as practicable. That will depend on a range of factors easily imaginable.
But I'm sorry, Sir Geoffrey, just pausing there for a moment.
Yes.
There may be a debate about that, although as soon as practicable means pretty well as soon as possible. It's not as soon as practical, it is as soon as practicable. Just leave that to one side for a moment, because that's a subsequent issue. What I want to know is, what does as soon as practicable govern? It governs after becoming otherwise interested in such contract.
Well, that's the starting point for the gun. That's when the gun goes off. And one has to identify what the Constitution means by, as you say, becoming otherwise interested in such contract. The way I have interpreted it, sir, is this, that a company or a partnership in which the member of the House of Assembly occupies a role either as partner or director or manager that enters a contract, in other words, becomes party to it, means that as that is the starting gun for the member of the House of Assembly who occupies one of those roles within such a company or partnership to have to give notice. Now, he can either do so before, as he would if he entered into a contract in his own right, or, and I imagine the purpose of the draftsman, and so I submit for provisional purposes at the moment, considered that a company might conceivably enter a contract without the member immediately knowing, because he's not in day-to-day charge, because another division of the company entered into it for a range of factual situations, I suppose, and so gave the option to the member learning after the event to be able to do it as soon as practicable. Now, that might invoke his knowledge, so it might not be practicable if he didn't know about it. But it seemed to me, sir, with due deference to no doubt you're grappling with it, that it may have and should be interpreted at least as meaning that if you are a partner and if your company, if your partnership enters into that contract, that you then become interested in it. I'm not certain whether that's what you're grappling at, and if there's a more specific or fine-grained point you want assistance on, I'd be very happy to see what I could do. But
that's the point I'd like some assistance on. But I just have some real problems with the construction that you've suggested. In terms of being a director of a company, under 67 subsection 3E, that's enough. Not knowledge isn't necessary or anything like that. If you are a director of a company which engages in a contract with the government, then you shall vacate your seat, subject to 7. But that's the starting point. Under 7, as I say, there are two limbs to the condition. The first is if such member before becoming a party to such contract as they're described. That's the contract in 3E. So we know what we're talking about there. It does not go on without a break, because there's a comma there. It does not go on without a break to say, or as soon as practicable after becoming otherwise interested in such contract. What it says is, comma, or before or as soon as practicable after becoming otherwise interested in such contract. So the before is a different before. It's before something different from the first part of the first limb of the condition. It can only be read in that way because we can't read the second before as having no substance. And so we've got to construe or before as soon as practicable after becoming otherwise interested in such contract. And so this way of becoming interested is not by becoming a party to such contract. That's dealt with in the first limb. It's becoming interested in some other way. And there may be other ways. There may be ways, for example, whereby the company purchases another company which has contracts with the government, or all sorts of ways. But I don't see how as soon as practicable can be as soon as practicable after becoming a party to such contract. I don't see how that's, with respect, even a construction.
I'm listening with interest to what you're saying, Commissioner, because of course this is I haven't heard this point and this construction. All I can say to you is that the words in brackets seem to have a relevance, whether a partner, so or before as soon as practicable, after becoming otherwise interested in such a contract, seems to some extent to be influenced and governed by the phrase in the brackets, whether as a partner in a firm or director or manager of a company. So it seems to be explicatory of the foregoing phrase. How you become otherwise interested would be as a partner in a firm or director or manager. Now, if that's right, so you become other, it may not be, and there is I completely accept that a difficulty of construction here. But if that's right, well, then how would you become otherwise interested in such a contract, whether as a partner, a firm director or manager? Well, I agree with you, sir, that it may well be that your company becomes a shareholder or otherwise interested in a company or another entity which has that contract. So I would agree with what you're saying, if that is a correct assessment of it.
I mean, and just to support that view that you've expressed, it would be strange and possibly bizarre if the second limb, as I'm calling it, excluded individuals who have a contract with the government, because it appears to be restricted to a partner in a firm or a director or manager of a company. So that means for any individuals, they have to, before becoming a party to a contract that's described in 3E, disclose it to the House. Otherwise, they have to vacate their seat. And if that's the case, which I think on the construction, as you've just outlined it, it would be nonsensical, wouldn't it? Sorry, it's a question. Wouldn't it be very strange if, although an individual had to do that, if you were a partner in a firm or a director or manager of a company, you didn't have to do that. But in any event, just looking at the simple grammar, or before or as soon as practicable after becoming otherwise interested in such a contract, clearly it seems to be on the face of it, it means something other than becoming a party to such contract. which is the first limb. Why is it? I mean, it'll be obvious to you as to everybody else why this is important, because if it is, if that construction is right, then if a director of a company does not disclose a contract that that company has with the BVI government before it's entered into, then he has to vacate his seat, because there is there's no exemption upon which he can rely. You're on mute, Sir Geoffrey.
I don't know why. I keep pressing unmute, but can you hear me now?
Yeah, thank you.
Forgive me, it's happening by itself. I'm not actually putting the mute on, so it's a technical glitch. May I say, sir, I can quite see your concern. I can quite see the construction that you are considering. It's not been drawn to my attention up until now, and I would like a little, if I may, time to consider it, time possibly to make further written submissions on it. On the face of it, I can quite see the potency of the argument that you make. It is not, of course, the way in which it has been historically interpreted in these islands. It has been interpreted, as I understand it, as meaning that if you are a director or a partner of a firm, it has granted to you the ability to, as soon as practicable after becoming interested in it, to make your relevant notice to the House. And of course, the House has proceeded on that basis and has done so for many years. One of the no doubt helpful contributions the Commission will make is to point out any potential errors of interpretation of this kind. But that it has historically been so, I don't think there's any doubt being considered so.
I'm sorry to interrupt, sir. Well, the first thing is, I mean, and I'll hear from Mr. Fliggleston-Davies and Mr. Rawat in case they can shed any illumination on this, which casts aside all doubt. But if they can't, then certainly this is something that I would like further submissions on, because it may be an important point, not simply for the purposes of the Commission of Inquiry, but Honourable Neville Smith said that he thinks, I'm not sure this is certain, but he thinks that as soon as tomorrow he has another such motion before the House of Assembly, and it may be, I would have thought, in the light of this conversation, that the House may want to take the Attorney's opinion before they do anything with the motion. It is not something that I want to rush, Sir Geoffrey.
Well, I would be grateful because the implications are significant.
Yes.
And if a historic, which is what I understand to be the case, practice has evolved in connection with this section, and those who have relied on that practice and relied on that understanding, and successive attorneys have sat in the House when these motions have been debated without pointing out that there may be a flaw in the interpretation historically and traditionally taken to it. It would, of course, have significant implications, and they would have to be thought of at the highest level and with real and serious consideration as to what the proper remedy was.
Absolutely, I fully understand that and agree with it, particularly, of course, as we're here looking at the Constitution. So
Exactly.
That simply enforces, I think, the point that you've just made.
It precisely does so, which is why I'd like, if I may, may I say at once that the construction you place, I see the force of, and I'm not going to say I necessarily disagree with it at this point. I'd like to consider very carefully both it and its implications, and that will require a little time, as I'm sure you understand. I would hope that this particular matter, if we could reserve it for a later point, because I wouldn't want to rush the very important considerations and constitutional ones, as well, as you rightly say, to which it gives rise.
No, Sir Geoffrey, I'll come back to you in terms of timing and form once I've heard from Mr. Davis.
But thank you for letting me know the precise point that was in your mind. It will give me an opportunity to reflect on it in more detail.
Yes, and reflect, I think, as you've identified, 2 points. One is the proper construction of the provision, and secondly, if the construction I've suggested is either right or has significant force, what perhaps should be done about it, if I can put it in.
That's the point. That is the critical point, and may take so longer than I'm afraid we have. I mean, this is a significant issue which will require serious consultations. I imagine, at every level of the government, not merely the executive, in considering it.
Yes, thank you very much, Sir Geoffrey. I mean, in terms of Honourable Neville Smith's evidence, and I think this is right. We made some evidence on this, but what you've said is that the construction you first outlined was the construction that has been either presumed or adopted for some time, and it may well be in those circumstances that, for example, no personal criticism of Honourable Neville Smith can be made in the light of advice that he's received or the practice there has been. But in any event, let me just put that to one side for a moment. Is there anything else you'd like to say at the moment, Sir Geoffrey, on?
No, not at all. I'm here purely to assist you and any points you raise with me, and I'm most grateful for this one. It's clearly a point of considerable significance. If there are others, I mean, there are one or two that occur to me, but it may be that they're not matters of relevance to you at the moment.
No, I think that's right, Sir Geoffrey. I mean, if I can put it this way, it will have been clear as we've gone through the inquiry that the construction that appears to have been routinely presumed or adopted in relation to a number of statutory provisions is not a construction that I necessarily agree with.
Well, I would, forgive me, I interrupt you, carry on.
No, and in some cases, it seems to me to be patently wrong, but those, I think, are for another day.
But I agree with you. It's a matter that where we have that opinion, we're referring to the attorney. It's certain of the matters are under consideration now. There is another issue in connection with this statute, if I might briefly adumbrate it for you. And it may be that you agree or disagree with it, but it does seem to us that the consequences of a failure to disclose a contract under Section 66, what is it now? 66, I think, 1F,
Yes.
may not have been fully understood in terms of the implications, in terms of its relationship with Section 67.
It certainly, Sir Geoffrey, if you stop there, I would agree with that. That is another point of some concern.
And it's a matter that I'm considering. What I hadn't done, I'm afraid, is because I came to this issue rather late, is grapple with, as you have, Section 67.7. But on any view, these interpretations have prevailed, and we need to think extremely carefully about how they're to be dealt with in the future.
There seems to be some lack of coordination as between Section 66 and 67, I think. But that's the point you make. Yes. Thank you very much. I mean, our focus today has really been on Section 67, and that's where the point that I raised has propped up.
I'm most grateful. Thank you.
Thank you, Sir Geoffrey. I think Mr. Rowett, probably Mr. Flickleton-Davis next, but both on section 67.7 and any other submissions you want to make on any other legal points. We've got the attorney's submissions, written submissions, and those put in by Silk Legal.
Well, if it should help, Mr. Commissioner, I think there are some points I can raise with respect to assisting the Commission with coming to an interpretation of section 67 as a whole. And those really relate to, firstly, whether or not the Constitution, as we know it today, the constitutional order, should be construed as a statute per se, because it's a statutory instrument of the United Kingdom's, the Privy Council of the United Kingdom, or should it be interpreted as a constitution proper? And I say that because there are a bit of differences as it relates to how one interprets a constitution. So, for example, in the case of Attorney General of Trinidad and Tobago and Whitman, it said that at page 5 of that judgment is that it doesn't fall to be that you have to give it a very flexible you have to give it a very flexible interpretation. So it's not restricted in the same way as a forgery statute may be restricted. There's also the Minister of Home Affairs and Fisher, where similarly at page 5, which stated that constitutional provisions should be interpreted more flexibly than ordinary legislation. Rather, it should be interpreted in accordance with rules suitable to its own character. Now, what that means generally for section 67D is something that I would have to, like Sir Geoffrey Cox, have to pay a lot more mind to, but certainly those two rules of interpretation certainly jump out at me, as particularly when it comes to the term contract. Because what we heard here today from the Honourable Neville Smith, and no doubt what the Commission has heard from other politicians, well, members of the House of Assembly that have talked on this point, if they have, is their understanding of what a contract is substantially different to what we lawyers understand contracts to be. And so for us, a contract is merely a promise to do a thing or to provide a particular thing in exchange for consideration.
It's a legally binding agreement.
It's a legally binding agreement for us. Any legally binding agreement is a contract. Now, as you heard from the Honourable Smith, and I think this is probably a view that pervades in the House of Assembly, is that a contract has additional requirement for them of being something written and signed, as opposed to I'm
sorry, Mr. Flickleton-Davis. I don't think that's what he said. What is said, I think by Honourable Neville Smith, but also other members of the House of Assembly, is that some do not accept that an arrangement involving a purchase order is a contract. Now, where I depart from your suggestion is, it is of course in writing. There's a purchase order, there's an acceptance, but some people do not act on the basis that that is a contract. Some people here. The Attorney General in her submissions says, well, it is a contract because it clearly is a contract. But certainly some of those in government do not have not traditionally recognised that as a contract.
I entirely agree with the Attorney General and yourself. As lawyers, you all know that it is a contract. A purchase order for us is naturally a contract. But I think the point is that given that the institution that is involved in the direct enforcement of this provision is the House of Assembly, mainly composed of laypersons, it would perhaps in the absence of guidance from the Attorney General, or general guidance, I guess, issued by the FCDO or the governor on the issue as to what a contract actually is, I'm not sure a criticism could be laid against them for not knowing that, okay, a purchase order is a contract, I need to declare it. But this also raises another point where, as relates to contracts, because if it is that a member is supposed to declare before they declare the contract before they get involved with it, let us imagine that we have a person that is a director of a supermarket, and some government department decides that they're going to buy some napkins or some groceries for some event for their kitchen or whatever have you from that supermarket. That director may not actually know that the contract even exists, or that they're even doing any business with the government in that respect. Yet, if we had a strict interpretation of Section 67, they would be mandated to vacate their seats, and that would actually have an effect of essentially excluding a certain class of persons from being able to participate in politics as a member of the House of Assembly. And that is something that I think the Commission might have to tackle with. How can we read these provisions together? Because Constitution has to be read as a whole.
I understand that. I mean, thankfully, because my task is big enough, I don't have to construe the whole of the Constitution. But there may be ways in which that can be addressed by the use of the exemption under Section 67. But the position I start from is that where the Constitution uses the word contract, those drafting it meant contract and not something else. If that has been misconstrued by members of the House of Assembly, whose legal advisor, the Attorney General, says that a contract is a contract, well, that's something which may have to be addressed. But the starting point must be that the words used in Section 67 of the contract mean what they say.
That is naturally the starting point, and that is why I was hoping to persuade yourself, perhaps, if we could use the rule of sui generis to perhaps say, well, a contract, in the absence of guidance, this is an acceptable interpretation, albeit not an entirely correct interpretation of the word. And so that is the point I would start off with. Now, as it relates to whether a person, the use of the term practicable, I would say that is largely a matter for the House of Assembly to determine what is practicable, taking into account the considerations of including knowledge, as Sir Geoffrey Cox raised earlier, of the contract even existing. Because if you don't know that the contract exists, how can you declare it? The case in point, again, the director of a supermarket, they may not know that they are dealing again with or even better, the director of a hardware store. Maybe Public Works frequently goes by them and purchases odd pieces of pipes just to make some repairs. And how is that director to know that they have indeed entered into a contract with the government? But by nature, because if we take the knowledge aspect outside of that provision, it would mean that they would have to vacate their seat.
The problem with that is this, that as soon as practicable does not govern the phrase becoming a party to such contract. It governs after becoming otherwise interested in such contract, which is clearly meant to mean at least something else. So far as soon as practicable is concerned, I accept that that requires an assessment by, in this case, the House of Assembly, possibly. But given that as soon as practicable means in ordinary language, almost as soon as possible, the leeway that it can give to that interpretation may be very restricted. But as I say, my real concern is not what as soon as practicable means, but what it governs.
I understand. With respect to, again, to interpret to the different ways of interpreting, counsel on the commission may be interested in Collymore and the Attorney General, which is, these are Privy Council cases. All that I've listed are Privy Council cases, so they're easily available. They're a bit aged, but they're available nonetheless. And Commissioner of Prisons and another, and C. Prasad and another, appellants 2021 UKPC 13, that may also offer some guidance.
And, as to what proposition?
Just as the way, just in the way that constitutions are interpreted as distinct from, as necessarily distinct from ordinary pieces of statute. That is, if the commission is of the view that it should be actually interpreted as a constitution rather than a statute. The other point on that I would also seek to raise is Section 11 of the Eastern Caribbean Supreme Court Act, which essentially allows, and this goes to all sorts of different things. So in civil proceedings, essentially, if there's an absence or an ambiguity as to a certain provision, then generally what the court will do is they use Section 11 of the Eastern Caribbean Supreme Court Act, or even other bodies, to see what the practice is in the United Kingdom, or specifically in England and Wales, actually, I should say. And then they would import that practice here, because the court would obviously be obligated underneath this section to be in conformity as much as possible.
Well, in terms of the principles of interpretation.
In terms of the principles of interpretation, but obviously if there is, sorry, not obviously, but if there is, for example, a practice of how to treat members after they have, if they become interested in the contract after, the second limb, we call it second limb, if they got how the second limb would be treated in the United Kingdom, if it is so treated, or there's such an equivalent.
Okay.
In the United Kingdom.
Yes, there may not be an equivalent, but I understand the point.
Yes. And lastly, it's just in relation to Section 66, and I think this is a point that what this seems to be as a whole, I think the Commission would accept, is that there's a lack of guidance and throughout the government, when private citizens seem to want to interact, or when they want to interact, or actually are interacting with the government. And so in that vein, what I would say is usually the responsibility, and it is the responsibility of the supervisor of elections to ensure those persons that are nominated comply fully with Section 66.
Know what to do.
Know what to do as well.
Okay.
And in the absence of that guidance, that critical guidance, and in absence of her actually enforcing him or her, I don't know, if it's now, but him and her, in absence of him or her enforcing that provision, then Section 66 practically collapses, because they've accepted the nomination, and that is the role and effect, unfortunately. I just have one more point to make. It was with respect to probably a suggestion, it's more of a suggestion than a submission, is that especially when it comes to contracts that involve national security, that should be declared before the House, and it's more of a recommendation, not a recommendation, submission as a recommendation, is that the office of the Registrar of Interest clearly needs to be expanded. It needs to be expanded to include a register of contracts that members are involved with, and if it is that it is a national security contract, then that would be of its own, but it would be so that only members of the National Security Council could access it. But that's just a suggestion.
I understand the point.
That's all I have to say.
Yes, Mr. Commissioner. And is that all? Do you want to make any submissions on anything else? You've dealt with Section 67.
At this point, I think that's the only thing I have to raise. The only other point would be to question whether that part in 67, whether a partner in a firm or director is exactly an exhaustive list.
I'm sorry, where are we, Mr. Fliggleston?
In section 67D, that would be the only thing that
67D,
where it says whether as a partner in a firm, director, or manager of a company, whether that is indeed an exhaustive list.
Okay.
Whether it could also mean an individual that just happens to have a trade license and is a tradesperson.
In 7, yes, okay.
That's it.
Good. And do you want an opportunity to put in written submissions on the 67.7 point?
I would definitely appreciate such an opportunity.
Okay. I'll come back to that. Mr. Rao, have you got anything to add at the moment?
Some very brief observations which may assist my learned friends in terms of any written submissions they may wish to make. Focusing first on section 67 of the Constitution. The starting point that we're at is 67.3, and the first point, which will be an obvious one, is that what 67.3 applies to is elected members. So for someone to be caught by the provisions, they must already have been elected to the House of Assembly. So if we then move on to 67.3E, that in my submission sets out all the circumstances in which an elected member might find himself or herself having to vacate the seat. And those circumstances, in my submission, the provision, and that is 3E, encompasses a DBA. It also encompasses being a partner in a firm or any company of which the person is a director or a manager. That then takes us to 67.7, which applies the exception. I would agree with your observations earlier, Commissioner, in that there are 2 limbs to the provision. The dividing line, which is one that no doubt will delight lawyers, is the comma after "there" described. So what we have is the first limb, which might be described or called the 3E limb, because that limb, if we read it, the House may exempt any elected member from vacating his or her seat under subsection 3E, if such member, before becoming a party to such contract as there described, and I say the there described points the reader back to 3E. And the consequence of that first limb is that the person, the elected member who is caught by 3E, has to disclose to the House the nature of the contract and his or her interest in it before becoming a party to the contract. Second limb follows afterwards, which is or before or as soon as practicable after becoming otherwise interested in such contract. One construction of that second limb is that the reference to becoming otherwise interested is to becoming otherwise interested than as described in 3E. And so the second limb could be called the non-3E limb. And it then is intended to capture any other circumstance outside 3E in which an elected member may enter into a contract with the government of the Virgin Islands. And in those circumstances, the obligation on the member who wishes to take advantage of section 67.7 is that he or she has to either disclose the nature of the contract in his or her interest before entering into it, or as soon as practicable after becoming otherwise interested in it. The final point I'd like to make, or the penultimate point I would like to make on section 67.7 is in relation to Mr. Davis's point about knowledge. That is something that you might want to have submissions on, Commissioner, because it seems to me, and in my submission, that becoming otherwise interested in such contract, so the requirement is to disclose after becoming otherwise interested in such contract, and that wording doesn't lend itself easily to an argument that you can wait until you have knowledge of it, because you become otherwise interested in the contract, because you have an interest either through a company or through some other arrangement. And that's what triggers it. The final point I'd make on 67.7 is the point that Sir Geoffrey makes about the need for consideration at the highest level. I would echo that, because clearly there needs to be a definitive view from the Attorney General on that. And we see it's not something that is just a theoretical argument. Heard from the Honourable Neville Smith. He is someone who is directly affected by it, and immediately so. And he is directly affected by it in two ways. Firstly, that there is a pending resolution before the House, but secondly, he has been in recent times, and that is July 2021, the beneficiary of resolutions. And if there is some doubt, and that doubt does not in any way allow a criticism of the actions of the Honourable Neville Smith, but if there is that doubt, it needs to be resolved. The final point I would make, and this is more just as an observation to my learned friends, is that if they are going to address you on the operation of section 66F as it bites on 67, then you may wish some assistance on the operation of 67.3D, which, as I've read it, would be one of the circumstances. What it does is explain that if an elected member is caught by a circumstance set out in section 66, then that would lead to them having to vacate the seat. But the only circumstance that doesn't apply is paragraph 66F, which is the one that we canvassed with the Honourable Neville Smith today. But other than that, at this moment, I have nothing further to add.
No, thank you, Mr. Rowett. Sir Geoffrey, I think it's back to you, and I sort of emphasise this because, as with everything I'm doing in the inquiry, it's my wish and intent to be as constructive as I can, whatever my findings might be. And so, in relation to this matter, it's important for all sorts of reasons, some extending outside the terms of the COI, that this is sorted out. You will no doubt report back to the attorney, given that Honourable Neville Smith's understanding is that he has got a motion for a declaration that is imminent, perhaps as imminent as tomorrow. I think it's true to say he's waited for quite a while for his declaration, and he may have to wait a bit longer, but that's a matter for the attorney and the House. But in respect of further submissions from you, Sir Geoffrey, how long would you like to do them? And it may be that the submissions will fall short of setting out a definitive opinion and route that is going to be taken. But how long would you like to think about this, consider it, discuss it no doubt with the attorney and others, and come back to me?
I'm not familiar with the attorney's schedule at the moment. It's always busy. I know from experience that it is the busiest of all in many ways. And the fact is that this is going to require a considerable amount of very deep thought, and indeed, I suspect, consultations elsewhere. Well, I don't suspect, I'm certain of it. The position, I think, if you could give me a week,
If you
hold up your inquiry. Frankly, it does seem to me that there's been a traditional understanding of this section. You have shed new light on it. We'll have to consider, I think, or the attorney will, no doubt, with some advice, as to whether or not it's one that the attorney should adopt, and in those circumstances, the question arises as to how the matter might be dealt with. So on the points of law, could we say initially at least, where are we now, Tuesday, next Tuesday?
So there's no problem with that, because this is not on the critical path of the.
No, that's what I imagine.
And so I'm quite happy to give you, to say the end of next week, to come back with some submissions, and I appreciate that quite a few people are doing quite a lot at the moment.
Yes.
But if you could come back at the end of next week to give a report on on what's happening and what the current view is, that would be helpful.
I will do that. Thank you.
Commissioner, may I add one thing?
Certainly, yes.
It may be that the Attorney General is asked to give formal advice to the House of Assembly,
Yes.
and in which case it's obviously a matter for her, but it may be that that is advice that you would be assisted by seeing.
Yes, I mean that was just an observation, Sir Geoffrey, and you heard what Mr. Rawat said, but clearly you'll have to think about this and discuss it with the attorney. And
with respect, I mean, I unless I'm persuaded by you or otherwise ordered by you, I'd be reluctant at this point to disclose any advice the attorney gave on this subject. It's a very sensitive issue. I appreciate that it wouldn't go further than the Commission, but you can be certain that any submissions I give will be on the instructions of the attorney.
What I'd like to do, Sir Geoffrey, is to see what you say a week on Friday, and we'll.
That's what I mean, really. That is the point.
And we'll take it there.
Yeah.
Mr. Davis, a week on Friday with submissions. Anything else, Mr. Ryan? Anything else, Sir Geoffrey?
No, thank you, Commissioner.
Good, thank you. Mr. Rawat, tomorrow. Yes, thank you very much.